May I
Yes.
plead your lordship, my lord, I pay for listing of a urgent writ petition on the reopening day, my lord. The matter is a tender matter, my lord.
Motion matter.
Motion matter, my lord. On the reopening. Oblige, my lord.
May it please your lordship. Your lordship, I also have a similar
Motion.
motion. We have filed it yesterday on reopening.
Urgency is.
Urgency because there's an issue, show cause issued by the GMD and GMCA under 87-88 for demolition. Thereafter, they have also cancelled our NOC.
Okay.
These are obliged, Lord.
Yes, Mr. Ganguly.
Asking for listing of two matters for admission. These are matters involving section 14 of the SARFAESI Act. Banks are the writ petitioners, service is complete. So these matters are ready otherwise for disposal. Because it's only
Matters of which year?
23 months. But the recovery of public money, my lord, or the physical permission by the DC is held up. Any date, my lord, I'm not asking for any date as per your.
Difficult, 23 matter.
But
To make a mention on the reopening, we'll see.
let it be on in first week February. Then it's
Okay, 2nd of February.
May please, your lordship. I pray for listing a writ petition on 18/1/24, my lordship.
At what stage? Motion stage?
Motion is there. We have filed.
Urgency is there.
Yes, my
What is
lord.
the urgency?
As you see, petitioner was a co-holder in municipal market in Pennsylvania. The municipality issued a notice for auction that so. Yes,
Okay,
sir.
okay.
Obviously.
May I please to lordship. Lordship, I beg to mention item number 56 of today's date. I want to withdraw this writ petition. Your Honor.
56.
56, lordship.
G. Agarwal.
Yes, Lord.
Sri G. Agarwal, Learned Council. Huh? Withdraw, huh? Irrigation, is anybody there? Irrigation? Who's the standing council irrigation?
I have already informed. about-
P. Upadhyay. P. Upadhyay, he is the council. Oh, sorry, N. Upadhyay. N. Upadhyay. Dismissed and withdrawn, yes.
Thank you.
Mercy, lordship. Lordship, I beg permission for a listing of two matters on the reopening day. As lordship, the registration of the under GST was cancelled by the.
Motion matter.
No motion matter. On the
When?
reopening day.
Why urgency?
Lordship, the registration has been business has been stopped. Registration, GST registration has been cancelled by the respondent authority.
When was it cancelled?
Lord, because the.
When was it cancelled? When?
On the 23 December 23. Lord.
What were we doing all this? Okay, we'll have it on
Deep-
the 19th, not on 18th, 19th. 19th.
Deeply.
May I please to beg to mention item number 30, 35. Lord. Ask about the further day, lordship.
35.
Aye.
You're for the petitioner.
Yes, Lord.
Adjourn for a week, huh? On the prayer made on behalf of the petition. Yes.
May I please, your lordship? Lordship, I beg to mention for listing of one writ petition for motion on the reopening date, lordship.
Why reopening day? Why on Thursday? What is the urgency?
Urgency is that is the tender matter by the agriculture department, and some of the participants were challenged before this court that matter is pending on 18th, Lord.
18th, okay.
Much obliged.
Please, your lordship. Lordship, with the consent of other side, I would like to mention item number 42.
42. Yes.
Lordship, regarding mention, we have no objection, lordship.
Hmm.
Here, lordship has given a status code regarding tender, lordship, on 20/12/2023, lordship. That day we are ready with our letter communication, but till today they have not supplied us copy. Lordship.
Lordship, I have asked my
So,
clerk.
Give a copy today
Your
itself.
lordship,
They have enjoying the status quo, lordship, but we are
A
not.
prayer
able
for
to take
adjournment
it.
has been made on behalf of the petitioner. Full stop para. Sri K. Gogoi, Learned State Council, however, submits that in spite of there being an interim order, extra copies of the writ petition have not been served upon him, and therefore he is not in a position to obtain concrete instructions.
Lordship, Lordship.
Full stop para. Sri, your name?
S. Gautam, your
Sri
lordship.
S. Gautam, Learned Counsel for the petitioner, undertakes to serve extra copies during the course of the day. Full stop para. List on when? List on 29th.
Lord.
29th. 1. para interim order passed till later continue till the next day of listing.
Oblige, your lord.
Give copies today itself. Okay,
May I please your lordship, I beg to mention item number 28.
yes.
Your lordship, the conducting counsel, Mr. S. Sharma is not well and the file is with him. Kindly adjourn the matter today. And
PHE. Have you informed the PHE?
we will inform them.
You inform the PHE, then you make a mention. Okay.
May I please, Lord? Lordship, this is a contempt petition regarding non-payment of contractor's bill. Lordship, here, petition disposed order was on 27/9/2022.
Which page, madam?
Lordship, it is on page number 16,
16.
16.
Please read the operative part.
And Lordship may come to page number 20. Here it is direction,
Okay.
number 3 point. Upon receipt of the amount, bills of the writ petitioner shall be processed and cleared within a further period of 45 days. Among the amount, he have received some amount, Lordship. 4,48,541. He have received that.
How much is the total?
Total was rupees 41,13,603 rupees. Your bank statement was given that he have received 448,541.
Where is your communication?
Administration. Lordship, it is certified copy had given.
Where? Where is the acknowledgement?
Here it is.
Is there any acknowledgement from the office?
No, Lordship, I have not received
Then-
that.
You have to give a forwarding letter, representation.
Petitioner has submitted only the certified copy, Lordship, this certified copy.
That how, where is the proof? Merely saying will not do.
But Lordship, petitioner had not received this kind of thing. Petitioner had not received that
Which order?
receipt or some kind
You
of.
can give by registered post with AD. Where is your statement, madam?
Lordship, it is on Annexure 3, page number 22.
What is there?
Page
That is the bank statement. Where is your statement in the petition that you have served them?
I have mentioned here para number 8 that I have received this amount.
No, that amount is not the thing. Where have you mentioned that you have served the order?
Lordship, it is on page number, para number 7. that
How have you verified para 7?
Petitioner submitted the certified copy.
You have to give some kind of proof, madam. These are contempt matters wherein there is a penalty involved. You file, you issue a notice to the LS contemptor and file an additional affidavit. We'll keep
Additional.
this pending. Heard Miss D. Angana, learned counsel for the petitioner, who by means of this petition has complained regarding non-compliance of the order dated 27/9/2022 passed in WPC 4699 of 2021. Full stop. However, though a statement has been made in paragraph 7 regarding furnishing of certified copy of the order to the respondent, there is no proof of such service, full stop. The consequence of a contempt case being penal in nature, it is incumbent upon a party to not only to inform the concerned officers but also to furnish proof of such service, full stop para. In view of the above, the matter is adjourned by 4 weeks to enable the learned counsel to issue notice to inform the concerned incumbents in writing and submit proof of such service by way of an additional affidavit. You're issued a notice immediately, otherwise immediately after issue notice, don't file submit certified additional affidavit. They have to be given some time. So we are asking you to take steps, file additional affidavit, it will come after 4 weeks.
Acknowledged, Lord.
Item 2. Yes.
Yes, my lord. The petitioner was awarded the work, my lord, for construction of road. He has completed the work. The part of the bill has been paid and part of the bill has been kept in withheld due to non-submission of as-bill drawing, my lord.
What is as-built drawing?
It is as-bill drawing after completion of the work, the engineer concerned employer has to submit the bills. Your lordship may find in page 101,
Which department?
this PWD.
Public Works,
Yes, ma'am.
101.
101. This is the bill of 7,75,000. In the last line, first paragraph, my lord.
101.
Yes, man. Page number 101.
Okay.
Last line, my lord. Further, would like to inform you that an amount of rupees 7 lakh has been kept withheld for non-submission of as-built drawings and others.
As-built drawing.
Yes.
Okay.
Though I have completed the
Is
work.
there a requirement under the contract to submit a non?
Yes, my lord.
Why haven't you done that?
No, I have to submit the data only. The department has to submit the as-built drawing after measurements and all.
Okay, madam, you're appearing for whom?
Lordship, I'm appearing for B. Gogoi,
For PWD.
ESP authority.
Do you have any instructions at this stage?
No, your lordship.
Okay. We'll issue notice. Heard Sri S.K. Deori, Learned Counsel for the petitioner. Full stop, Sarah. The petitioner was awarded with a work wide order dated, in pursuant to an NIT dated 31/3/2018. Full stop. It is the case of the petitioner that the work was successfully completed and part payment was made. Full stop. However, comma, wide communication dated 16/10/2021.
Yes, my lord. There is three
And,
communication.
Wide subsequent communications, comma, the balance payment was withheld on the ground of non-submission of, within inverted comma, as built drawing, as built, B-U-L-T, drawing. Full stop, para, it is submitted that the aforesaid obligation is that of the department
Yes.
and not of the contractor. Full stop, para. Let notice be issued. Returnable. 4 weeks, by 4 weeks. Madam, your name?
A. Bothakur, Lord.
MS A. Bothakur, Learned Counsel, appearing on instruction of Sri B. Gogoi, Standing Counsel PWD, accepts notice on behalf of all the respondents. Let extra copies be served upon her during the course of the day.
Okay.
Okay.
Yeah, please. I am coming against settlement of a market, lordship.
Hmm.
What happened, lordship, this particular market is, lordship, some of the portion of shops are in private land and rest, some are in government land, lord. One katha is of government land is there. Apart from that, the pata lands are there. Without segregating those shops, lordship, the notice was issued for inviting tender and subsequently settlement was granted, lordship.
Okay. You are the owners of the Patta land?
Pata land.
Yes, Mr. Doctor.
My lord, admittedly, there is a, my lord, market, my lord, with a proportionate land, my lord. That is admitted fact, my lord.
Now,
Therefore,
is the land which is where the market is running, does it also cover the lands of the
My
petitioner?
lord, their case is that, my lord, that their lands are adjacent to the market. And maybe the lessee, my lord, they may took some,
Encroach.
yes, maybe, my
You
lord.
take
That is-
instructions, we'll issue notice.
My lord, or lordship may kindly come to the prayer portion, my lord.
Yes,
Prayer is not for demarcation, my lord.
then,
Prayer for entire cancellation of entire NIC, my lord. That is the problem.
no, you,
Page 80.
no, if he is able to make out
Yes.
that your official position covers his patha land, then he might have a point to justify his prayer. But if
Page,
he,
Lord, page
yes,
73, Lord.
okay,
It is their letter, Lord. They have admitted it.
page,
In
Page
fact, my lord,
73, Lord.
okay, you take
in
instructions.
fact, I want to enlighten one more thing, my lord. In fact, 107 was unconstitutional, declared unconstitutional by one judgment, my lord.
Hmm.
But the Panchayat Act 1994 has been amended recently, my lord. And 107 again inserted, my lord. But may I read, my lord, 107.
What is the context?
My lord, regarding the private market, my lord. Yes. 107. No private huts and fisheries shall be allowed to operate within the area under the jurisdiction of the Gao Panchayat without prior approval of the concerned Panchayat authorities and government. So earlier 107 was that we can issue NIT on the private lands also. That was declared unconstitutional. But at this point, my lord, to run a private market also, my lord, prior permission from Panchayat is required, my lord. So their case is that they have some adjacent shop, my lord, and admittedly there is a market we are running, my lord. So that is
Okay,
admitted.
heard Sri U. Dr. Learned Counsel for the petitioners who have put to challenge our tender process for settlement of the, what is the name of the market?
Oguri Daily Bazaar.
Oguri
Oguri
Daily Market.
Palm, Oguri Daily,
Oguri Daily.
Daily Bazaar in the district of Morigaon. Full stop. It is submitted that the market also encroaches upon the private patha lands of the petitioner, and therefore the rights of the petitioners are adversely affected. Full stop. Para. Let notice be issued. Oh, no, Sri S. Datta, Learned Standing Council PNRD, however, submits that though the grievance is of encroachment, comma, even assuming for argument's sake that such grievance has some substance, comma, the same would only amount to some illegality by the lessee, and the entire tender process cannot be cancelled. Full stop. Para. Be that as it may, comma, let notice be issued returnable by what is the tenure?
Up to 30/06.
Okay, we'll fix the date then. It's a 1 year.
Yes.
Yes.
Why have you come so late, Mr.
But
Doctor?
earlier it was filed, Lordship. There was a stay order. Subsequently, it was withdrawn and refiled, Lordship.
Yes, when? On 2nd of, is it okay? 2nd, can you come back? 2nd February, Friday.
5th February, man.
Hmm?
5/2.
On, today is what? 18th, okay.
Today is
You
12.
can get it on 2nd, what is it?
I'll try, man.
2nd of February.
But in the
2020.
meantime, from private land, they may not be
That I have
allowed to.
objection, man.
That we have to take instruction without factual determination. We'll say something, okay. Sri Doctor, the Learned Standing Council accepts notice on behalf of respondent numbers 1 and 2.
1, 2, 4, 5. 1, 2, 4, and 5.
1, 2, 4, and 5.
My colleagues were
And
three.
K. Gogoi, State Council for
Three.
3. Extra copies during the course of the day. Steps for service of notice
6 and
upon the
7.
respondent number 6 and 7 be taken by registered post to TD. Can you take steps by today?
Lordship, I can.
Possible? Today.
I can hand over that, but Lordship, in the office.
No, office, it's not up to you. Can you hand it over? Can you
Yes.
take the steps?
Lordship, I can.
Kali working, nahi. Kali not working.
I will provide the extra copies today itself.
You take steps by within a week.
Sure.
That registered possibility within a week. Okay. Para, Sri Dr. prays for an interim order. Full stop. Sri U. Dr. Learned Counsel for the petitioner prays for an interim order. Para. Let instructions, specific instructions be taken on this regard by the Learned Standing Council for consideration of the interim order.
Apply.
Item 4.
May I please allow? Lord, the petitioners, my lord, there, my lord, traffic license porter, my lord,
Where?
and Guwahati, my lord.
It's a railway station.
Lordship.
It's a CGC, anybody? Gogoi, Gayan, who is appearing? Railway.
Railway.
Whom do you serve?
Fully. Their name has been shown, my lord.
Yes.
Fully license, cancel good.
Your license has been cancelled.
License has been
You issue
cancelled,
notice.
my lord, without
Yes,
of
Lord.
giving an opportunity.
When was it cancelled?
And it was cancelled, my lord, on 11/2019.
19.
Then we file appeal, my lord, immediately.
Okay.
Appeal is still pending, my lord.
Why did you dispose of the appeal, madam?
Yes, sir. Well,
From 19 to 2024, appeals are pending. It's not
They
possible.
passed an order, my lord.
one thing may be done, my lord. One thing may be done, my lord. We fix it immediately after vacation. I'll take instruction. What is the status of the appeal,
No,
my
we'll
lord.
issue notice. We'll say pendency shall
Yes.
not be a bar
Yes, my lord.
if not already disposed of.
Yes.
Okay. Heard R. Ali, Learned Counsel for the petitioner. Petitioners.
Petitioner, two petitioners.
Petitioners, full stop. The petitioners are aggrieved by cancellation of their traffic license, traffic porter license,
Lord. This
which
32.
they were on the strength of which they were rendering their services. Where?
Railway station, Guwahati, my lord.
In the Guwahati railway station. So what did you do?
Now, do we carry, my lord, luggage, my
No,
lord?
no, what did you do to entail this cancellation?
That we file appeal, my lord.
What misconduct?
Or lost it. Allegation that we took more money from the passenger. On that ground, my lord.
That you have done, I have seen myself.
On that ground.
Mr. Chaudhary has also seen. No, he doesn't visit the railway station. He visits,
Lord,
he uses air.
an FIR was filed.
But it's very common.
Lord.
But your rates are also very less. You have to increase the rates. In today's context, can they run it with that rate? কি করবে দোস্ত? Full stop. It is submitted that against the cancellation order, comma, they have preferred appeal before the appropriate authority, which however are still pending. Full stop para. Let notice be issued. Returnable by 4 weeks. Miss A. Gayan, Learned CGC, accepts notice on behalf of all the respondents. Para, let extra copies. Para, pendency shall not be a bar for consideration and disposal of the appeal, comma, if not already disposed of.
Okay.
May be a lordship. Lordship, the matter pertains to D. Budal, lordship. Attack D added lordship before the name, lordship. While he-
Okay, you have an order?
Yeah.
Okay. Correct it
Yes, sir, I'll correct and fetch.
and show it to him. Okay, you correct it and give it to our court master,
Yes, sir.
dispose of.
Lord.
6.
Give your name, please.
P. Ulaskar.
B.U. Laskar. And who's appearing for the other side?
I pay for
I Ali for the
2, 4, and 5.
2, 4, and 5.
I'm for matter 3 and 7.
J. Payang. You're for FT?
Yes.
The standing council FT for 3 and 7. And K Gogoi for state council for respond was 6.
Comply.
I think 6.
Yeah, please. But if it is though, my lord, the construction work, my lord, petitioner not relating, my lord, the security money, my lord, though petitioner completed the, my lord, completed the construction work, my lord. As per the job completion certificate, my lord, that is page 333, my lord, on 6/8/2021. One, my lord, the construction of, my lord.
Heard 3 L and Hingia learned counsel for the petitioner who is aggrieved by withholding of the performance bank guarantee in connection with an work order dated 13/7/2017. Full stop. It is the case of the petitioner that by the aforesaid work order, comma, the construction of, within inverted comma, Sasoni Marbil Eco-Tourism Project Dibrugarh was, bracket close, was handed over to him, which the petitioner claims to have been successfully completed. Full stop. Para. Let notice be issued, returnable by 4 weeks. 3.
Their lordship, they are standing council of ATDC is their lordship.
Who's their name?
Name lordship, I forgot. Otherwise,
My lord, after notice, it should, my lord,
so lordship may issue formal notice, registered post lordship, they will come up with 1, 2, 3, and 4 lord.
But if there is a standing council, we may not burden the council. Can you take instructions? Who is the standing council?
my lord, as per, I mean, filing section, my lord, after issuing notice, my lord.
Okay,
they may
okay,
be
okay.
available.
Okay. 4 weeks. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps within a week.
Master.
Item 7.
My lord, item 7 and 8 are similar matters. There is a non-payment of, my lord, contractor bills. My lord, they have supplied, my lord, blankets and merchandise, bleached cotton hanky yarns in the year 2016, my lord. Then, my lord, we have approached this honorable court, and honorable court, my lord, pursuant to an order, my lord, dispose of the writ petition. And in the light of, my lord, another writ petition, the set of writ petition that has been disposed of.
Okay.
And accordingly, my lord, a high power committee has been set up, and the report has been given by the high power committee. On the basis of that report, my lord, we have been paid some amount. And the remaining amount, my lord, in the year 2021. Since then, my lord, we are not getting the
Now,
remaining.
did the high power committee come to a finding that you are entitled to?
My lord, the high power committee come to an.
Where?
My lord, high power committee report is, my lord.
Where is your consideration?
My lord, on the basis of that report, we have received the amount, my lord.
No, that is what we are asking.
My lord.
The amount, you say that the amount which you have received
My lord.
is only a part of the amount which you are entitled to.
Lordship.
Now, was your entitled taken into consideration by the entitlement taken into consideration by the high power committee?
Lordship.
Where?
My lord, the report of the high power committee, my lord, is annexure, my lord. 11, my lord.
Page
number. '84.
Yes.
Yes, these are the best of, my lord, read petition. 84 is the order. High power committee report is, my lord.
The high power committee report ends at 83. Where is your consideration?
No, here, my lord, it is written, my lord. This is at page, my lord, 72, annexure 10, my lord.
Okay. Yes.
My lord, matlab, several matlab, this matlab, contractors were there, matlab. As at a lot, matlab, the entire aspect has been taken into consideration, matlab, together, matlab.
Mr. Doctor,
Matlab.
before the writ court, your submission of this nature will not do.
Matlab,
This will be a civil dispute. You have to go to the civil court.
matlab,
We have to, you have to show before us prima facie that this is the amount I am claiming and this is the amount which they have acknowledged. Now, how part committee has said that you are entitled to something? You said that you have only got a part of it.
my
But
lord.
where is that acknowledgement that you are also entitled to the other part? Or this is the entire whole amount which you are otherwise entitled to?
My lord,
Your claim, how can we
my
adjudicate?
lord, that my lord, they have given my lord on the after my lord to not only to me, my lord, to several my lord, all the my lord, they have released certain amounts, 28% in the first installment, another 28% in the second installment. So all the my lord,
You show us that part of the high powered committee that this is rupees 100 is your entitlement, and they have said that we are, yes, you are entitled to rupees 100.
Here, my lord, lordship, may I read the my lord, report of the hyper committee?
No, not all the part,
My
only
lord, they
that
are saying
part.
that, my lord, they are in this report, my lord, it is specifically stated that entire materials we have supplied. This is specifically there, my lord.
Where?
That-
Where is the report?
My lord, in page 70, the committee has examined the relevant records and reports and findings as follows. All the suppliers are supplied, at page 74, last paragraph, all the suppliers have supplied the materials in full quantity and as per specification which were duly received by the concerned district subdivisions officers of the handloom and textiles. Accordingly, all the materials were distributed to the so and so numbers of approved beneficiaries of the state. It is my lord at page 74, last paragraph.
What are your names? Who are the petitioners?
When the petitioners here are, my lord, this Guwahati Industrial Sales and Service, and in the another, my lord, Guwahati Industrial, my lord.
Yes, where are your names here? In page 74.
When the names, my lord, this, my lord, we are under the, my lord, Assam Government Marketing Corporation Limited, Guwahati, my lord. We have supplied on the, my lord, through them, my lord.
No, there
We
are
have made party here, my lord.
there are 6 names here.
Keep the number 2, my lord. Assam Government Marketing Corporation, AGMC, my lord, Limited, Guwahati. Through them, we have supplied.
Difficult. Okay, we'll issue notice. Heard. Sri R.K. Datta.
User Sakya, my lord.
Oh, sorry. User Sakya, right. Heard Sri User Sakya. Learned Council. For the petitioner, separate order for Twitter, who by means of this application has prayed for a direction for release of contractual bills for supplies made. Full stop. It is the case of the petitioner that on an earlier occasion, comma, the petitioner had approached this court and this court wide order dated. Is it 21, 2016?
Not sir.
Order dated 21. Wide order dated 16/11/2000. No,
20.
16. No. Where is it? Page
Page, my lord, my lord. Last.
80? No. The first case where the high power committee was directed to be constituted.
Well, that is my lord, 28/6/2019.
Wide order dated 28/6/2019 had directed constitution of a high powered committee to examine the matter. Wide order dated passed in a bunch of writ petitions. No? Para. The Learned Council has referred to the report of the committee and has submitted that in spite of the recommendation of the committee, comma, only a part of the payment has been made. Full stop. Para. Let notice be issued, returnable by 4 weeks. Yes, Handloom Textile, madam, you're appearing.
Sir.
Your name?
It is on behalf of Mr.
Ardhar, naam to likhiyo, huh? I'm a student of Learned Council. Appearing on instruction of Sri Ardhar Standing Council. Handloom and Textile Department accepts notice on behalf of respondent numbers 1
Three.
and 3. Finance Department, anybody? You,
RM Barua, Your Lordship.
RM Barua for
Italia.
Italy. MS RM Barua Learned Council accepts notice on behalf of on behalf of the Finance Department, respondent number 2. And government, Assam Government Marketing Corporation Limited. Anybody?
Lordship, let notice,
You will also take notice.
let notice. Sir.
Okay. You can let extra copies be served upon the Learned Council. Can you serve it today?
They have standing council, we have served upon them, but.
No,
I
no,
don't
no.
know.
These councils
This council I will serve today.
today. And so far as 4 is concerned, take registered post.
No.
Steps, let steps be taken for service of notice upon respondent number 4 by registered post daily. Steps within a week.
Well, but the dependency of these musicians shall not be a permanent, because they may pay.
4 weeks you have said. Let's see. Come back with instructions. Yes, next.
Well, sir, 8 is also similar.
It's in. The reference to the earlier order is the same.
Same.
May I? This is also, my lord, contract payment, my lord. The petitioner has executed, my lord, work in the year 2013, my lord. And bills were submitted, my lord, but till date, no payment was made, my lord. My lord, work order is at page, my lord, 10, my lord. On several locations, my lord, the executive engineer, my lord, Karimganj, my lord, had demanded, sent letters demanding fund, my lord, but fund was not made available.
Where is the acknowledgement?
Acknowledgement, my lord, they have sent letters demanding the fund, my lord. But
Where?
those letters are not, the executive engineer, my lord.
Where?
I have stated, my lord.
Stating will not do. This is a matter of 2013.
Yes, my lord.
What you cannot get in a civil court, how can you get in a writ court?
My lord, they have demanded the fund, my lord.
Where? So the demands will not do. There has to be an acknowledgement in writing. And that too within the period of limitation.
That acknowledgement we have not. There is no.
Unless you give the acknowledgement, you are not going to entertain this kind of petitions. What were you doing for all these days?
We have submitted several representations, my lord.
Then you keep on submitting representations.
Right.
Why did you come to the court after 10 years?
2016.
You suddenly
17,
become a wise after 10 years.
my lord. In the year 2016, we have submitted several representations.
From 16 to 24, 8 years.
16
What
and
were you doing? What explanation?
2017 also. we
You
have-
furnish proof of some acknowledgement. Otherwise, you are going to dismiss this. Do
Sometime.
I heard 3K of the Learned Council for the petitioner who has filed this application for a direction for release of bills of works done under a contract under the Water Resource Department. Full stop. Para. Sri S. Sharma. Sri Sharma, Learned Standing Council, however, submits that there is no acknowledgement of any kind in this writ petition. Para. In the interest of justice, matter is adjourned by 4 weeks to enable the petitioner to bring on record any acknowledgement within the prescribed period so as to prescribed period so that the matter can be and after that the matter would be taken up for consideration. Yes.
My lord, item 11, 13, 14 and 16 are same.
Work order of which year?
Same year, 2013.
13. Okay, same order. 11.
11, 13, 14 and 16.
Okay. Ask your clients to have some documents, file additional affidavit too.
Right.
Okay. Item 10.
But this matter may be adjourned for the for the time being, Lord.
Time being not possible. On, is there any urgency?
Yes, Lordship, there is, I think. Yes.
What is the urgency?
Actually,
That-
Lordship,
Hmm?
this matter, Lordship, there was a order from the regional commissioner.
Challenging the attachment order of the regional provident fund.
ACC,
Yes,
Yes,
Lordship.
why haven't you paid?
Lordship, the government is not providing funds. We are giving, placing for budget, Lordship. But
You know the provisions, how strict the provisions.
yes, Lordship, but sometime maybe in this
Notice
repetition,
may be issued, my lord.
Hmm?
Notice may
notices
be
maybe.
issued.
What is the stage now? Have you attached?
Recover-
already?
My lord, kindly see page 37. They are telling this attachment order is issued already.
Already to
Yes,
issue.
sir.
We'll issue notice then. We'll fix a date. Where is the attachment order page?
Page, last page, my lord, 37.
What have you attached?
Property mentioned below, my lord.
Where, what property?
The detail matter.
Hmm?
A plot of land in
Yes.
Hailakandi and
Heard Sri Sri Sharma Learned Counsel for the petitioner who has put to challenge an order dated 15/12/20 2023 issued by the recovery officer, comma, Employees Provident Fund Organization. Put by the said order, comma, the immovable property of the petitioner has been attached because of default in terms of the Employees Provident Funds and Miscellaneous Provisions Act, 1952. 52 Act, correct?
Yes, yes.
Full stop para. That notice be issued. Returnable on. We fix a date. ASTC.
Yes.
Date.
Okay, the start date may be given. And
Returnable on. Can you come back on 29th?
okay, Lord.
29th, returnable on 29th of January. Sri S.K. Chakraborty, Learned Standing Council. Regional Provident Fund Commissioner accepts notice on behalf of the sole respondent.
Lordship, till the returnable date.
No,
the
my lord,
notice
that-
may be stayed, Lordship.
Attachment, how do you stay? And you have an provision for appeal also.
no, their
That-
appeal,
that-
no
that-
appeal lies because, my lord, it is penalty and interest only against provident fund. my lord.
Okay, come up with instructions.
Yes, ma'am. Keep your.
Okay, Lordship.
Yes.
I
what
know
is it?
this is an efficacious petition. Actually, the Minister of Industry and Commerce implemented one scheme for the tea garden, for development of tea garden. But as per that in scheme, I am eligible for that and accordingly I have complied all these requirements. So I filed the application in no objection was issued. Thereafter, the department, tea board is keeping silent. They are not taking any action or release.
You are
of the
for?
property.
I'm for, yes, my lord, all right.
What is phone number?
I'm for CG, appearing for CGC, lordship. For all different. I can.
Oh, you are the CGC. Okay.
appeal.
You are not, your grievance is that your applications are not being processed.
Process. The delay is because of the
When did you submit the applications?
application has been filed in 2016. Has completed uprooting and plantation is completed 2019 and 20. Map and
Heard-
everything has been given.
Heard Sri D. Sahu, Learned Counsel for the petitioner who submits that pursuant to a scheme for availing subsidy, comma, the petitioner, which is a company engaged with tea cultivation, had submitted an application. Full stop. However, it is the case of the petitioner that in spite of fulfilling all the requirements of the scheme, comma, the applications have not been processed. Full stop para. Let notice be issued, returnable on Yes. Returnable on, you want a date? Returnable by 4 weeks. Three so and so London CGC accepts notice on behalf of all the respondents.
All-
Let extra copies of the writ petition be served upon him by today.
So glad.
Mr. Mishra, try to give it by today itself.
Now for the time being passed over the meter,
What is the matter, madam?
pending of non-payment of bill.
Not going to bills. Who's for the other side? Union of India. Madam Gayan, what is this?
Your Honor.
Madam Gayan, what is this? Which is department? Ministry of Home Affairs. Deputy Commissioner, Custom. Have you served upon the Customs Council?
Customer, they have their own standing custom.
Mr. Kayal,
Yeah, yes.
you served upon Mr. Kayal, we'll have it on the next date. Have you served upon Mr. Kayal?
Yes.
You have? Names or not? Huh? Name shown or not? No,
Name
no.
not shown.
You served on the Standing Council Customs, okay? This court has been informed that the Customs Department has a Standing Council. Full stop para. Let a copy of this writ petition be served upon Sri S.C. Kayal, the London Standing Council, and the matter be listed for motion on 19th.
May I please, your lordship?
Yes.
My lord, petitioner before your lordship, my lord, the government of Assam has, the official department, my lord, Assam Tea Corporation Limited has given on lease, my lord, long time lease to the 12 tea states all over the Assam. Petitioner, he has taken the lease of the Sibsagar packet with regard to Deepling and Rajabari tea state, my lord. After taking over possession of one of the tea states, that is the 17 is Deepling and item number 21 was Rajabari, my lord. My lord, what happened was that he came to know, my lord, that I have annexed, my lord, that out of the land of the total tea garden, my lord, 73 numbers of persons have occupied, my lord, 178 bighas of the land of the tea state, internet. And my lord, out of, and 11 numbers of persons have occupied 25 bighas of land in which they are doing their own tea cultivation as well as bamboo cultivation, my lord. So, and my lord, as per the lease deed also, after taking over possession, he came to know that 60 numbers of worksmen are more in pay book than those numbers given by the government, my lord. As such, my lord, he has filed representations. He has filed 5 numbers of representations, my lord. None of the representations are considered because he is not in a position to evict those persons, neither he is in a position to let those encroachers go because it is the department who can do that. And the respondent authorities, they are not responding to the reasons based to no name, well, political reasons or whatever the reasons may be. But petitioner, he cannot enter the tea state because out of the total land, most have been occupied by encroachers, and they are the worksmen of the company itself, and some are non-worksmen, my lord. So here, my lord, the petitioner has filed representations starting from 11/9/2023 to the last representation at 2/1/2024. In between, he has filed 5 representations to consider his case only to the ground that to evict those encroachers and to take steps, my lord. None of the representations are considered. He has been issued notice to pay the wages to those persons who are not even in the list, my lord. And he has paid the wages also, my lord. Now, my lord, the position is that he took security arrangement from the superintendent of police to enter the tea state because he gave objection, my. So, my lord, this petition has been filed by the petitioner, praying for the steps to be taken, direction to the
Okay,
respondent.
okay, who's for the,
Officially, the main authority, Lord, Assam Tea Corporation Limited, Lord. I'm representing respondent of 4, Lord. My sister is for.
Industries and Commerce Department? But who will consider, madam?
My lord, with regard to the 60 worksmen, that is the ATCL. But
is
with
where I
regard to
remember
the
it.
other main issues, my lord, illegal encroachment and everything, that is the department, my lord.
Department,
The respondent number, if the local, then respondent number 4, the deputy commissioner, and it is the 1 and 2 also, my lord. Because,
but while taking the lease or bidding for the.
no, my lord, I have on record,
It's
while on list, my lord, this fact when I have given statutory, even my note, those were not informed to us.
No,
we-
no, that is what, while taking the lease, it is on where is, as is basis.
Yes, as
You did not inspect at that
my
point
lord,
of
I
time.
have one letter. I have one letter. After taking over the,
So
before,
far as your allegation of having 60 numbers of
The-
extra
yeah.
workers,
yes, my
that
lord.
is something we can
That
take
is-
care of.
Oh, my
That
lord,
is not the issue. That should not be a
lord.
difficulty. But about the encroachment, of course, these are not, we are not endorsing
My lord,
even for a moment.
yes, my
But
lord.
you knew that there was encroachment. You should not have.
My lord, those were the laborers of the tea garden, and those were, my lord,
Okay.
while entering, my lord, those were all tea gardens.
Heard,
Postman part
Yes.
also, Lord, we have no rule. Respondent number 4 has no rule.
heard. Ms. S.G. Borwa, learned counsel for the petitioner. Full stop. Pursuant to a person to a process for person to a request for proposal, person to an RFP
Correct.
floated by the ATCL, Assam Tea Corporation Limited, ATCL, comma. The petitioner had participated and was duly handed over the Dipling Tea Estate and the Rajabari Tea Estate.
My lord,
Your problem is with Dipling.
Dipling and my lord, item
Both.
21 is the Rajabari,
Your problem is with both.
both, my lord. Issue is different, but with 17, the issue is, item 21 is Rajabari, my lord, here to be.
Oh, there are two items.
2 items, my lord, 17 and 21, 2 tea estates.
And in the other case, what is your problem?
The demarcation, as per it was stated, take it as on basis, and in the lease deed, it was stated the demarcation of the land will be done in between, and there is also access of workmen. There is official letters in between. We have filed representation that all the demarcation process in the other tea states have been done. Why the, even in Dipling it was done, but why Rajabari, no steps have been taken.
Okay. The present petition pertains to Dipling Tea Estate, full stop. It is the case projected by the petitioner that after taking over possession, comma, it was detected that large portions of the tea estate were under encroachment, and further, comma, there were extra numbers of workers than over and above the list supplied
In the
by
paper.
the ATCL at the time of the RFP.
Right.
Full stop. The representations of the petitioner has also not been considered as yet, causing immense difficulties and hardships to the petitioner. Full stop. Para. Or it would be like to say. So in this case, Rajabari is concerned. It is projected that though the area of the tea estate was required to be demarcated, comma, the said process of demarcation is yet to be done. Full stop. Further extra workers to yet to take. Issue notice returnable on. Yes, when? It's we fix a date. On 2nd of February. Yes, Industries Commerce, M. Kolita. And Kolita, Senate Council accepts notice on behalf of respondent number 1. Revenue Department, G. Hazarika, Standing Council Revenue Department 2. ATCL, anybody is there?
Notice me go also,
Okay.
they have the council. also.
And Sri K.
I'm
Gogoi,
for
Learned
four
State
also.
Council for response number 4. Let extra copies of the repetition be served upon the Learned Council during the course of the day. Our steps for 3 by registered posted AD within 1 week.
Right. Oblige me.
A2 hobo, Aru, which I did, I don't,
21, my lord.
21.
Oblige me.
Hmm.
I'm sorry to trouble your lordship.
Mm.
Lordship, in item number 10, lordship.
Mm.
Lordship, we have challenged the order dated 15/12/23.
We have passed orders.
Lordship, yes, lordship. The thing is that, lordship, in the
Huh?
lordship, there is a prayer for interim order.
How do we have stall an attachment order?
Lordship, because we have already filed an appeal before the.
Now, how do you stall an interim order of an attachment order? What kind of interim order?
Lordship, otherwise they will attach one by one property of the.
That we cannot, these are statutory liabilities. How do you expect an court to pass an interim order in attachment? It amounts to final relief. Are you apprehending that third party rights should be created?
Lordship,
Are you apprehending that any third party rights should be created?
no, Lord.
Then we have said we'll consider it on the next date. What can I do?
I'm sorry, Lord.
Yes. Yesterday's matter.
That yes. Matter, my lord, regarding, well, now kindly see a tender which has been quoted at page 22, my. Okay, good. 22.
Just a minute.
Yeah.
What is it? What is it? 22.
22, this is awarding toll advertisement right of Guwahati station at page 22.
Tender document for awarding sole advertisement right.
Of Guwahati station and circulating area non-lit over Lamding division. Dated is 25/7/2019. See at page 23, my lord.
Right at Guwahati station.
Oh, yes. Now, and circulating area, which is outside the also circulating area. Kindly see at
What
page
is non-lit?
non-lit is here. Non-lighting, lighting.
Huh?
It's not been non-lighting.
Non-light, no lighting.
No lighting.
And over Lamding also.
This is over Lamding division, man. Over Lamding division.
Okay.
Now, my lord, see 23. 23
Hmm.
is a tender for awarding. These are dates.
Yes.
Period of contract is 5 years. Lord, you got it?
Yes, yes.
Base price is 44 lakhs, 34,750. We quoted 2 crores, 62 lakhs, 65,162. This is the base price.
Yes.
We quoted and we were the highest and we got the work. There's no dispute about them getting the work.
It's awarded.
Yes, yes. Now, kindly
By
see.
which order you have been awarded?
No, this is not there. The contract. This is not been
At least
denied.
date of the contract?
Date of the contract.
17/11.
17/11/22
For 5 years.
for 5 years.
Okay.
Now kindly see 41.
Yes.
These are the 41 are the location which are in dispute now. With the railway says that now you have to vacate. They see, my lord, Guwahati, name of the station area, Guwahati, identified location space, TC Club Circle, TC Point Circle, TC Point. This is a TC Point. Total 6, my lord. Kindly see the size, number of hoardings, 3, 2, and 1.
Yes.
That is 6. Now, this is, my lord, fine. Absolutely, there was no dispute on it. Now, 46, now the problem start with 46. Your lordship will keep in mind, this is the only TC point is the only dispute. These 6 hoardings.
Okay.
46, kindly see, this is the problem start. Now, this is the request for proposal, which is grant of lease for residential cum commercial development
on railway land at Ambari Guwahati Northeast Frontier Railway for 99 years. My lord, all those hoardings, which my lord, opposite to the masjid, there is a hoarding, all these hoarding. So back to that, where earlier the food stall were there, the TC point, this, my lord, it belongs to railway. So this is what was given lease to my lord for commercial development. Now, my lord, but this is not, absolutely not, I am not, my lord, this I am not a bidder also in this. This is the problem which arose. Now, my lord, now, what has happened, I'll tell your lordship, when this particular notice was invited, what they have done, my lord, they said, the holding which you have put, that also is a part where you have to now vacate it. Because that is a part where we have given residential commercial complex. Now the contract is with us, which is for 5 years. Now, my lord, my lord, this is 2021. Kindly see that date.
9621. I have brought it. Yes.
Lordship got it?
Yes.
49 is they have called for a joint survey on 4/7/2022. Kindly see 49. Joint survey. We wide work so and so awarded sole advertisement. Now it has been planned by RLDA to take over the proposed land of Ambari for further handing over to developer. But during the time of inspection of the site of RLDA, some hurdles in forms of hoardings were noticed. In this connection, you are requested depute any your representative to attend this office on day and carry out a joint survey for identification of hoarding installed by you at the site and identification of alternate area of installation of hoarding. Your cooperation in this regard is solicited. Now, this is at page 50. This is an inspection report.
Yes.
This is a joint.
Where page?
50. That is a joint survey report. First paragraph important.
50.
50. Next page.
Yes.
This is dated 8/7/2022. First paragraph important. As advised, a joint survey was conducted along with concerned SSC, repenting of message Priya Communication to identify the space for reallocating the 5 numbers of hoarding measuring 3340 square feet found displayed in the proposal of Ambari near TC point. Now, in order to these hoardings, a joint survey was conducted by the undersigned in various places over Greater Guwahati area. During the survey, total space of soils have been identified, which may be utilized for reallocating the existing hoarding from Ambari or as under. So these are the area which they have identified. Alternate area. Now, my lord will kindly see. So now what they say, further mentionable that total 5 now unauthorized hoarding found display in various areas in railway land, out of which 3 numbers of unauthorized hoarding in Nunmati area and 2 numbers Jalukbari found display which need to be. This is absolutely fine. We are not concerned on this. Is unauthorized, they have to remove. Now, my lord will kindly see the contract which they have entered. Date is very, very important. Kindly see next page as 51.
Yes.
Date kindly see 17/11/2022. After the joint survey, they entered into a contract with us. 17th of November 2022. Now, kindly see at page 53, location at page 52, location and under details are under page 52C. C and kindly turn to page 53. 53.
Yes.
Serial number 9, 10, 11, 12, 13, 14. This is TC point. So they kept. TC point they kept. After joint survey also they kept. They say unauthorized, you remove it. But this particular was kept by them. All this 9, 10, 11 up to 15.
Which unauthorized?
Unauthorized, they said no by letter, my lord, at page 50. That's a different area. Not connected with this, my lord. Not connected. 50 I read, my lord.
Okay.
This is not this area, my lord. This is not the area.
Okay.
This is a contract which they have agreed. Now 53. 9, 10, 11, 12, 13, 14. Lordship got it?
Yes.
Now, my lord, 54 is the license fee. 54.
54 is what?
54 is the license fee
Where?
at F4, 4E.
Okay.
4E. Contract, my lord, is 2022, but they started, my lord, operation 2019, where they have taken the license fee. Kindly see first year license fees 70,0900 paid. Lordship got it? By 24/9/2019, DD number so and so. Second year nil, 360 were COVID, my lord. End of a contract period, according license fee will be realized. End. Now, third year, 68,74,581. 7 days will be added at the end of the contract period. License will be realized. Out of which, my 35 lakhs paid by DD, dated so and so. Fourth year, fifth year, 78 fourth year. Fourth year also paid, partially we paid. Fifth year also, we have not paid. So this is the mode, my lord. No, period has not been over also. Period is, my lord, 2025. Contract may be of 2022, period is
19/12/24. Page 9.
12/24.
No, if it starts from the first date of paying the license fee, that is
Yes.
24/9,
Yes,
then it 5 years have to be counted from 24/9/19.
yes.
So it will be in sometime in September to 2024.
But COVID extension is there, my lord. COVID extension.
Maybe it go to 25, maybe.
Yes, right. That's what I. 54, it is written at down below. Bottom, kindly see, 372 days, COVID-19 extension, bottom. I have to pay license fees. It's not that I don't have to pay license fees. My lord, kindly see 56 now.
Okay.
56.
Okay, correct. Yes.
Any more
56.
addition, alteration, change, modification, review can be made to this agreement only with the mutual consent of the licensee and the railway administration as per schedule of powers applicable on Northeast Frontier Railway.
Okay.
Now, my lord, there is a clause of arbitration at page 64. I should point out that also. At paragraph 18, if there is a dispute. Now, 68, 65 is legal jurisdiction liability. It's Guwahati High Court. Kindly see, my lord, at page 65, 19. Okay, my lord. 19.
65.
65. One, I have shown arbitration. 65, my lord, 19. Legal jurisdiction liability subject to arbitration. All disputes are subject to jurisdiction of High Court, Guwahati. So, and 65, 19. Now, what we have given an offer to them at page 68. They asked for vacating, my lord. Then we made an offer.
Where is that demand or the direction for vacating?
That's a subsequent 68, my lord. 68. 14/12/2023. After the contract period, same point. Kindly see, my lord, in connection with matters stated above, RLDA has previously, that is Railway Land Development Authority, RLDA, has previously scheduled the acquisition of designated land in Ambari. This land is intended for subsequent handover to the developer. Consequently, RLD has advised the removal of your existing advertisement hoarding in the area. To facilitate this transition, a joint survey was jointly conducted by so and so and a representative from your company. The primary objective of the survey was to identify a suitable location for the relocation of your hoarding. Now you request, we request that you promptly proceed with the relocation of a hoarding under the supervision of so and so has been identified in the joint survey. Please ensure that this relocation is completed by 2012-2023. Now, if your lordship kindly see at page 69,
Yes.
I made a representation to them
Yes.
on 22/12. This was 14/12. 22/12, I made a representation. Regarding the sole advertisement, my lord, initially they have done it, my lord. Kindly see, however, third paragraph, Second, however, we encountered several issues while displacing our media at different locations. Firstly, the Jalukbari under bypass, Dunlop Bridge media place were handed over to the state government, resulting in a substantial loss to us. Secondly, TC Point media place was given to another party where we also removed the hoarding from there. Additionally, Guwahati Rail visibility of 2 numbers of hoarding and was affected by opening of a coach restaurant shop in front of the ignorant area. Now, kindly see, my lord, the next paragraph. Let us conclude with a request for the matter to be taken seriously, expressing the hope for a favorable resolution. We also indicate that if the issue persists, we request you to waive off 40% from our future license fees payment. We said, okay, fine. If you want, you can take, but huge amount has been paid. My lord, these are display which very important location. You take to another location which doesn't have a value. Now, my lord, at page 71, this is 2812. They refer to the repetition, my lord. They refer to repetition, my lord, 2812, our repetition. Now, what they say, in view of reference, you are requested to remove the hoardings from Ambari TC Point immediately under supervision and designated land has been scheduled for acquisition of RLDA, and the land is intended for subsequent handover to developer. Moreover, your request to waive a future license is currently under consideration. We will inform to you once approval is received. They said your particular, I make a request. They said it is under consideration. We don't know. This has the approval. This has the approval of the competent offer. Now, I have absolutely no problem, my lord. If this 40% is waived, I have no problem, my lord. Otherwise, these are important points. This is our case, my lord. If they come up and they said, okay, we agree, absolutely no problem.
Question is whether we can alter or not during the persistence. Lordship, can you come to page 31?
No, see, Mr. Chakraborty.
If your lordship is issuing notice at this stage with no interim order.
Mr. Chakraborty, he is not even asking or challenging the decision to relocate. He is saying that it may not be feasible to relocate from TC Point or to other place. And he, as a contractor, he has all the rights to say that I am not interested in any other point.
Will be entitled to waiver.
Waiver point.
That will be under active consideration as per.
Waiver point, you have not on principle, you have not said no.
No, we
You
have
have
not
said
denied also. We have not
no,
denied.
you have
also.
said it's under process. You may say no tomorrow. That's a different matter. But it seems that you are considering. You come up with your instructions.
But no interim order, Lordship.
What kind of interim order?
That he will not be entitled to sleep.
Huh?
That he will not. be-
Are you apprehending anything now?
Yes, they will remove it. What will do it? So let it
Lordship,
be.
the question is
My
whether
lord,
we
let
can
it
remove or
remain.
not.
Let it remain till they come up with a proposal. We will.
Are you seriously going ahead with the project immediately?
Maybe Lordship.
no,
Because
not
IITA party notices to go to them. Lordship.
Maybe you'll not do. You have to,
Lordship, question is whether we have power to relocate or not during the subsistence of contract. Lordship, may kindly see page 31.
so Mr. Chakraborty, we are not even going to that question. Yes, you may be correct that if relocation is held to be not permissible by law, he may be entitled to compensation.
Without any protest.
But why do you go for this thing, confrontation? He is saying that you consider my prayer for remission or reducing the license fee.
Lordship, that's a policy decision of the central government to use the optimum use of the railway land. It is so IRD has been that's why constituted.
Is he challenging the construction? He is not challenging.
No, I'm not.
So why are you going into those issues which are not even for consideration?
The question is whether we can relocate or not.
He's not even.
One clause, only one
He's
clause.
not even challenging relocation. He has an
He
alternative
said
prayer.
that that will not be profitable to him.
He is saying that you consider my case for reducing the license fee by 40%. And if you go strictly by the inspection, your inspection.
Joint survey.
Joint survey was done when?
22 Lordship. They are also sitting idle.
No. When was the joint location?
Page 50. Page 50.
It was 8/7/2022.
Yes, Lordship.
And you have the contract of the signed on 17/11. You are very much conscious about the joint.
This effective from 2019. so
That is
5
it.
years.
You had very well. You
That's a
were
normal
in
practice.
fact, you had all the mechanism within you or powers that do its narrating from 19 in view of the
That's
joint
a
survey, we are
normal
not
practice
going
in the
to.
railway, Lordship, the agreement entered into subsequent dates.
Don't
Lordship.
take any adverse action now.
Yes.
Come back, come up with
That's
instructions.
perfect, sir, Lordship. Even the agreement, Lordship, only one clause, Lordship.
You come up with instructions.
Lordship, only one clause.
Don't destroy anything now. Third, Sri D. Das Senior Counsel for the petitioner. Full stop. It is the case of the petitioner that pursuant to notice, pursuant to a process initiated by the railways, comma, the petitioner was awarded a work for installing hoardings, and in the instant case, comma, the controversy is with regard to 6 numbers of holding at TC Club Point, correct?
Yes.
TC Club Circle. Full stop. It appears that though the work was continuing from the year 2019, comma, the formal agreement was entered into on 17/11/2022.
Yes.
And the tenure for 5 years was also taken into consideration. And the tenure was for a period of 5 years, full stop. It appears that the period of COVID was also taken into consideration, as there is an extension by 372 numbers of days. 372, I think?
Yes. Yes.
Full stop. The Learned Senior Counsel has also drawn the attention of this court to a communication dated 8/7/2022, whereby there has been a recommendation for relocation of the 6 numbers of holdings in view of the commercial cum residential complex which was contemplated to be constructed on the railway land.
Yeah.
Adjoining the holdings, full stop. It is also pointed out that in spite of such recommendations, comma, the contract dated 17/11/2022 had clearly stipulated that the petitioner will be allowed to have their holdings for the tenure given in the contract, full stop. Para. The grievance of the petitioner is with regard to a communication dated 14/12/2023, whereby the petitioners have been directed to relocate the said holdings, full stop. The said communication was replied to by the petitioner by the communication dated 22/12/2023, whereby the feasibility of relocation has been, whereby the issue of feasibility of relocation has been raised, and in the alternative, comma, the petitioner has prayed for reducing the license
Yeah.
fee by 40%.
Correct.
Full stop. The communication dated 28/12/2023. However, 23 suggests that such request is under process. Full stop. Para. Sri Das, the Learned Senior Counsel, submits that if in the meantime, comma, the hoardings are removed, comma, the petitioners would suffer irreparable loss.
Yeah.
Puts the para. Let notice be issued. Let notice be issued. No. On the other hand, comma, Sri B. Chakraborty, Learned CGC, appearing for the railways, has submitted.
Contract periods from 2019 to 2024. Their own admission at page 9.
372 days.
Lord,
Why are you raising this kind of question, Mr. Chakraborty? You see the schedule. COVID period 372 days.
they'll be entitled.
So-
If they are entitled, that will be given.
What if they are
Whether we
entitled?
are entitled to relocate or not. That is the
That is
question.
nothing to do with the tenure.
Yes, Lord.
Why are you raising the question of tenure?
Because it's a.
We would have raised, this has been explained. And it's a part of your common document.
My submission.
372 days.
Page 31.
We are recording your submission. Before recording, how do you know what we are recording?
I'm sorry, Lord.
We are trying to record your submission.
Lord.
B. Chakraborty, Learned CGC, appearing for the railways, has submitted that the project in question is of public importance and there is no restrictions on the part of the railways to direct relocation or to remove the hoardings.
Modify or alter.
Full stop. The contract, the clause, there is he has also pointed out that the contract itself gives the power to modify,
Oblique alter.
alter the conditions of the contract. Full stop. Para.
The location. The location.
Conditions of the
The
location. Modify, alter the location. Full stop. Para. Be that as it may, comma. Let notice be issued. Returnable on. Yes, when?
Not take out.
29th. Can you come back on 29th? 29/1/2024. Sri Chakraborty, Learned CGC accepts notice on behalf of all the
Except the
respondents.
IRDA, Lord.
Who is the IRDA?
RLD. RLDA.
Okay, for 1, 2, 3, 4, and 3 and 4.
1, 2, 3, 4, Lord.
Let extra copies be served upon him during the course of the day. Why not railway land?
They have their, just like the IRCTC, they have their own council. If they come up, we may also appear.
Now you take notice if there is something for all the respondents. Let extra copies be served upon him during the course of the day. Full stop. Heard the learned Senior Council. Heard the learned, heard the parties on the interim prayer. Full stop. The communication dated 23/12/2023.
28/12.
28/12/2023. Depicts that the request for waiver is under consideration and further that the petitioner would be informed once approval is received. Full stop. Para. This court is of the view that since the prayer for reduction of the license fee is under consideration, comma, till the next date fixed, comma, let no coercive action be taken against the petitioner in terms of the 6 numbers of hoardings in question. Full stop. The aforesaid interim order, however, will be reconsidered on receipt of the specific instructions by the Learned Standing Council.
Item 19.
Yes.
This litigation has some checkered history, Your Lordship. The petitioners before Your Lordship are involved in the transportation of LPG cylinders through trucks, Your Lordship, of the IOCL, Your Lordship. Now, in 2019, Your Lordship, a tender process had been initiated by IOCL for transportation of trucks from various bottling plants. Those tenders were challenged in a writ petition, Your Lordship. And in an order, this Honorable Court directed that the rate which IOCL had fixed, Your Lordship, was unviable and unworkable So the tender process was stayed. So while that interim order was operating, IOCL cancelled that tender process. And thereafter, Your Lordship, several rounds of deliberations have been held between the IOCL, the petitioners, Your Lordship, there is an association also, which is not before Your Lordship, and the government of Assam. And in those meetings, Your Lordship, there were three contentious issues primarily. The first issue, Your Lordship, is that the rate is about the viability of the rate fixed by IOCL. The second issue, Your Lordship, which is the core issue, Your Lordship, is that IOCL, in order to pressurize the petitioners into accepting a lower rate, sought to give a preference to distributors of IOCL, Your Lordship, who have nothing to do with transportation. The third issue, Your Lordship, which we are not raising now, is regarding unpaid dues of earlier contracts. Now, the petitioners, Your Lordship, are here because, Your Lordship, they have instituted a new tender process, again for similar work, Your Lordship, where, Your Lordship, they have sought to give an undue preference to distributors, Your Lordship. The petitioners are directly invoking, Your Lordship, the principle of level playing field, Your Lordship, that unless there is some overwhelming public interest, preference cannot be given to any party in a tender process. So if I may just take Your Lordship to some of the documents, Your Lordship.
Show the clause.
Yes, Your Lord. That is at page number 178, Your Lord.
What kind of preference?
The preference is that, Your Lordship, firstly, the age of the vehicle is an objective criteria which they have sought to fix in the tender document. That beyond a certain age, you cannot even offer a vehicle.
Okay.
But as far as the distributors are concerned, IOCL has said, regardless of whoever comes out as L1, distributors will be given the first preference at the L1 rate. All their vehicles, regardless of age, would be filled up. First, their vehicles would be allocated. And after that, Your Lordship, for the remaining part, these transporters would come in. But the scope of work of the tender would reveal, Lordship, it is a highly technical tender only to deal with transportation. Now, if distribution and transportation, Your Lordship, are two completely different fields, Your Lordship. If at all a preference is to be given to somebody, Your Lordship, then it is supposed to be given to transporters because it's a highly technical business, Your Lordship. But what IOCL has done is that distributors of IOCL who offer their own trucks, regardless of their vehicle, all they have to do is match the price and their vehicles will be given preference over even a newer vehicle of a transporter, Your Lordship. And whereas IOCL themselves has said that age is one of the objective criteria on which this tender is to be assessed, Your Lordship. For example, if there is a tie between two transporters regarding price, the criteria to break the tie is the age of the vehicle. But the clauses are framed in such a way that a distributor, even
Let us see.
Yes, Your Lordship. Page 178.
178.
178.
Yes, please.
Yes. Clause 4, Your Lordship. Indian LPG distributors can offer trucks in their name, limited to their own requirement as given in Annexure 1 of this tender document. Such trucks shall be treated as own-use trucks. Trucks will be first allocated to Indian distributors qualified for own-use trucks at L1 rates, starting from the lowest age of the truck till the requirement is met. All the trucks qualified for own loads will be listed as per ascending order of their age. Then on the next page, Your Lordship,
Yes.
next page, clause 11 at page 179.
Yes.
It is said evaluation will be based on net landed cost to IOC. Net landed cost will be arrived as defined below. There is a formula. Below that it is stated, Your Lordship, L1, L2, L3, etc. shall be decided on percentages quoted in the price bid and shall be tabulated in ascending order to determine the ranking of each bidder. In some cases, percentage rates are quoted. If same percentage rates are quoted by more than one bidder, then for each such rate, such bid shall be considered for further ranking, L1A, L1B, L1C, etc. on the basis of ascending order of average age of qualified owned trucks quoted by them in terms of number of days. Now, Your Lordship will kindly just one more clause regarding this point of discrimination regarding age of the vehicle at page number 195.
195,
Your Lordship.
This is a part of the tender conditions, clause 1.6. 1 minute. The trucks attaining the age of 15 years or as stipulated in NIT during the contractual period shall be removed from the contract. Replacement within 30 days with another eligible truck having age of less than 15 years shall be the responsibility of the concerned transport contractor, failing on which action as per contract agreement will be taken. Now, what this means, an older vehicle, he'll get a reference with an older vehicle. Once that vehicle crosses the age of 15 years, which is the threshold fixed as per the tender, even then he will get the first chance to give a replacement vehicle. And a person who has probably even turned out as L1 with a newer vehicle, he'll be left out of the tender.
Well, how do you?
What will happen, Your Lordship, is
Now, please read again.
the trucks attaining the age of 15 years or as stipulated in NIT during the contractual period shall be removed from the contract. Replacement within 30 days with another eligible truck having age of less than 15 years shall be the responsibility of the concerned transport contractor, failing which action as per contract agreement will be taken. Now, the distributors, regardless of whether they come up as L1 or not, will get first preference on allocation. That preference on allocation.
Let us see that clause again.
Yes, Your Lordship. Clause 5, page 78, clause 4 and 5.
178.
170.
Yes.
Indian LPG distributors can offer trucks in their own name, limited to their own requirement as given in Annexure A1 of the standard document.
Okay.
Such trucks shall be treated as own use trucks.
Okay.
Trucks will be first allocated to Indian distributors qualified for own use trucks at L1 rates, starting from the lowest age of the truck till the requirement is met. All the trucks.
What is 5? Trucks will be first allocated
to Indian distributors qualified for own use. Now, clause 11, Your Lordship, shows what will happen after the requirement is met. It says ranking procedure after allocation of own use trucks. That is why 4 says such trucks shall be treated as own use trucks. And clause 11 says ranking procedure after allocation of own use trucks. So first, all the trucks of the Indian distributors will be allocated regardless of age. Then the ranking process of transporters will start.
Mr. Chaudhary, what is the meaning of 5? 5 at page 178. Please read 5.
Some of the distributors, they have their own truck for their own use.
No, see, 4, there is no problem. Indian LPG distributors can offer their trucks on their own. You also include distributors to be a part of the transportation system. No problem with that. Let them compete. Then 5.
Trucks will first be allocated to Indian distributors qualified for own use truck at L1 rates, starting from the lowest age of the truck till the requirement is made.
Suppose a distributor, he competes, but he's not the L1.
No, he is the L1, my lord.
No, at the L1 rate.
Yes, at the L1 rate.
Some transporter may be L1.
Yes.
But he'll be given the preference that you offer your.
Yes, there is a reason behind, my lord. There is a policy decision. There is a reason behind, my lord. Suppose there is a distributor who has his own truck and he has got his customers nearby. Therefore, he will use it for his use. But the transporter will go to different places. And my lord, the distributors, the number of the trucks the distributors have are very limited. In fact, my lord, I have the figure. I have received, my lord, instructions. I will file affidavit. Now,
is there any concept of a retailer and a distributor? There is no such concept. For an LPG cylinder, distributor is the place where everyone goes and collects their cylinder.
Yes, that is the distributor.
And distributor also may have the have the responsibility of delivering, making a home delivery.
Yes.
Now, that transportation part is another job.
Yes. Because my lord.
It is not a part, essentially
there-
part of the distribution.
There are
job.
many distributors who do not have trucks.
Correct.
Those are being supplied by other transporters or my lord, other distributors. Trucks. So my lord, this is limited to own use of the particular distributor. And that is a my lord, policy decision of the my lord Indian Oil Corporation Limited, which is being my lord utilized, being my lord effective pan India. And in fact, my lord, although the petitioners have relied on the documents and representations later submitted by the association, they have come on individual capacity. It is not although my lord, it has been stated Northeast Pact LPG Transporter Association, other states, my lord, in other states, we have already given the my lord NIT on the basis of this, and that process is on, my lord. No, there is no objection. They are in effect, my lord. In fact, my lord, if I am given an opportunity, I have instructions. I'll file the affidavit, my lord. Last date of submission of tender is 31st. But before that, my lord,
31st of what? January.
31st of January. We've got time, my lord. Before that, your lordship will kindly see this document. What happened, my lord? Although the petitioners have come individually, they have given a strike, my lord, lightning strike notice yesterday, and they are resorting to strike from today. And my lord, one of the petitioners, he is the my lord, president of the association. My submission before your lordship is that either they should ask for examining this matter by your lordship, by this court, or they should resort to strike. They cannot have two, my lord. They are taking the public at ransom. In fact, my lord, only 2 months back, they had resorted to, my lord, 4-day strike. There was a big problem, my lord. Thereafter, there have been discussions, communication, and my lord, they have been explained that with this rate, you'll make more profit now, because they are the existing contractor.
Mr. Chaudhary, you were just hinting upon that there are less numbers of distributors who really have their own transportation system. How many do you have the statistics?
Yes, my lord, I have the figure, my lord. The total number of, my lord, trucks that the distributors own all over Assam is, my lord, 257.
And what is the requirement?
Requirement is, my lord, in these tenders, 1,107.
And you are also saying that the preference to the distributors is only for his own use.
Yes.
He cannot use his vehicle for
For
distributing
other-
somebody else's.
It cannot. And this policy decision, I'll place all the documents, my lord. And before that, my lord, I'll implore your lordship, my lord, they cannot resort to strike in
Yes,
a, my
Mr.
lord,
Pathak.
essential service, my lord,
what is this?
and ask this court to examine the matter.
Firstly, I'm not holding the brief for the association.
No, you are one of the petitioners. Petitioner number 15 is the president
He's here.
of the association.
I'll just, your lordship, because I strike, your lordship, I'm not condoning. Is what the association has decided. Because this is the first time I'm hearing about it, honestly.
No, but then they are
No,
relying on all the
Mr. Pathak,
documents.
Mr. Pathak, we are not saying anything or not making any comments
Yes, your lord.
on your having a decision to go for a strike.
Your lord.
Any democratic process you can resort to, but at the same time.
Of course, your lord.
How can you?
LPG, your lordship, all of us.
But let us not
Lordship,
go,
I'll just-
no, let us not go to that extent.
Lordship.
Then 31st is the last date
Lordship.
of submission of bids.
Lordship.
And after that, the decision will be taken. It will take some time. You submit your bids. In the meantime, you have contract instructions. Bring this on record. Let him also have instructions from his client.
I have got received.
Because these are, in our view, it's a very relevant thing which Mr. Pathak will have to explain.
I'll only show lordship the definition of own use truck one.
That is okay. You,
So let them not resort to strike, my lord, then. If your lordship is examining, my lord, let them not resort to strike.
that will not
This is
like
essential
will
service,
not
my
like to
lord.
say anything at this moment without.
Essential service, my lord, public interest, they are taking the public at ransom, my lord, and come to court.
I understand the lordship.
Okay, we'll issue a short notice.
Right.
You take instructions. You are free to submit your bids.
Very well.
Submission of bids will be without prejudice to your rights and contention you are raising. Heard Sri KP Pathak Learners counsel for the petitioners. Full stop. The petitioners who are 16 in numbers have made a challenge with regard to contract, regard to a notice inviting tenders for transportation of LPG cylinders. It is submitted that that an earlier policy of 2019 was the subject matter of challenge,
In 2019, it was a subject matter of trial.
My lord, a
in which
new policy has come by.
in which there was a stay order. Full stop. However, the entire tender process was cancelled, and thereafter parleys were held by the petitioner and their association on certain issues. Full stop. By the impugned tender process initiated wide notice dated 24/11/2023, comma, it is the contention of the petitioners that certain clauses have been inserted which are not only legally tenable but are meant to cause prejudice, legal prejudice to the petitioner. Full stop. It is specifically submitted that distributors are also given the scope to participate in the tender process of transportation, which has been claimed to be a specialized job. Full stop. It is further submitted that though per se there may not be any complaint with allowing a distributor, comma, the tender clauses are such that preference would be given to them and thereby a fair process of distribution of state largesse would be adversely affected. Full stop. Para. Per contra, comma, Sri M.K. Chaudhary, Learned Senior Counsel representing the IOCL, has submitted that the grievance expressed is both factually and legally not tenable. Full stop. He submits that apart from the fact that the number of vehicles that can be offered by a distributor would constitute only about 10%,
No, my lord.
20%.
20%.
About 20% of the total requirement, comma, the use of a transport by distributors would only be limited for his own distributorship. Full stop. The Senior Counsel has also submitted that while on the one hand, comma, this writ petition has been filed challenging the contract in question, comma, wide a communication issued on 11/1/2024, comma, the Transporter Association of the Northeast Pact LPG are going for an indefinite boycott. Full stop.
From today, my lord.
Huh?
From today, my lord. From 12.
From 12/1/2024. Full stop.
And the president is the my lord petitioner.
He has specifically pointed out that the president of the association, who is also a signatory to the communication, he is the petitioner number 15. Full stop. Apart from raising the issue of the Senior Counsel has also submitted that the commodity in question is essential in nature and any hurdle in its smooth functioning would cause immense hardships to the public in general. Full stop. Para. Let notice be issued, returnable on. Yes, when?
Short notice.
Tell us.
22nd.
22nd, no, 25th. 25th is okay? On 25th of January, Sri M. Sharma, Learned Counsel, assisting assisting Sri Chaudhary, the Learned Senior Counsel accepts notice on behalf of respondent numbers 1, 2, 3, and 4. 1, 2, and 3.
123.
State
Four.
Council, K. Gogoi, State Council for 4, SS Roy, CGC for 5. Let extra copies be served during the course of the day. Full stop para. This court has been submitted that the last date of submission of bids is
31st of
is fixed on 31/1/2024. Full stop para. It is provided that the petitioners would have the liberty to submit their bids, which however will be without any prejudice to their rights and interest raised in this petition.
I renew my prayer, my lord, let them stop this strike, my lord, till the matter is, since the matter is being examined. Let them not resort to
That we
strike.
cannot say. Make a challenge.
Lordship, may I make a prayer that
You instruct your client.
I will. Lordship, may kindly make this tender process subject to the outcome of this petition
No,
because
not-
once
not-
third party rights are
On the,
created.
on the next day, I'll satisfy, my lord, this is a frivolous petition, and my lord, your.
We are having
like
a
to-
match before.
Lordship may then grant me the liberty to renew my interim prayer on the next day because once third party rights are created, your Lordship, then a whole Pandora's
No,
box will be
interim prayer,
opened.
Your worship will consider on the next date, my.
That may be reflected.
The interim prayer may be renewed. When are you fixing?
25th, your Lordship.
25th, renewed on the next date fixed, that is 25/1/2023.
Deeply.
2024. Okay, we'll come back.
Deeply. Okay.
For issuance of IMFL like that. On earlier, the same order was challenged, but we don't know, divided file of that matter. So at this stage, may I pray for issuance of notice, my
What is your challenge?
challenge, my lord, 8/12/23, my page 50.
What has been done?
By this order, my lord, his license was directed to be issued in favor of private respondent, my lord. The last paragraph, my, of page 50.
You are also a contender.
I am also contender, my lord. Without.
No, you are also a contender.
Yes, my,
You also wanted the license.
my lord. Without considering my case, my lord, there was no.
Is it given by a public offer or what?
It was a person to tender. He had participated.
My lord.
Okay.
Lordship,
Page
the
20.
last order, I had the previous order passed by your lord. Identical petition. I did not find it. I did not understand why he withdrew it.
No, we done annexure E, my lord, page 30, my lord, and fair part, my lord. There was, in earlier, my lord, there was defect in my fair.
Okay.
Same order we can pass, we record your name, PN Goswami Jaga to record you.
Only regarding prayer disturbance,
Huh?
only regarding prayer order.
4 weeks. Same respondents,
Same respondent,
it's the respondent number 5 by within a week.
my lord.
Within a week. Where is the earlier dispose of the withdrawal part?
My lord, withdrawal, last
ये
annexure,
लिख दीजिए यहाँ पर
page 50.
at the outset एक पैरा लिखे हर पहला पैराग्राफ के बाद इसके बाद at the outset the learned council has however informed this court that though WPC 7313 of 2023 was filed on this issue, comma, the same was withdrawn on 8/1/2023 with liberty to file afresh. उसका बाद ये बोला जाए. Notice of motion 4 weeks.
My lord, last part, any order passed in persons of 8/12/23, my lord, then will be outcome of the.
What will you get? Some satisfaction, okay. All
Already
actions,
there, already there.
already there.
My lord.
What is?
And
what
last
is
line,
that?
all action pertinent to the order dated April.
You don't want that line.
I want to that line.
That'll be there.
My lord. All right. Okay.
This is relating to non-payment of higher charge, my lord. And already, my lord, report has been submitted before the Office of the Director General of Police, my lord. With after a negotiation, 20% less negotiation, my lord, and thereafter nothing has been happened, my lord.
Where is it?
Is it at page number 49 annexure 4, my lord? It is the letter sent to the Assistant Inspector General of Police, my lord, by the Superintendent of Police, Dhubri, my lord. And before that is the higher charge, my lord, at annexure 3, page number 47, my lord.
3 M.A.I. Hussain, learned counsel for the petitioner, who by means of this petition has prayed for a direction for releasing of higher charge of his vehicle dash Mahindra Bolero bearing registration number AS17K5145. Bolero Power and Bolero are different vehicles. You are more powerful. What is this Bolero Power? We have not heard of such a vehicle.
In the RC, my lord, it was written, my lord.
Power.
That power is in RC.
Let us also put power. Mahindra
The model.
Bolero Power, huh? It is submitted that on the aforesaid issue, there has also been deliberations whereafter directions has been made for payment by deducing certain amount, full stop. However, till now, no payments have been made. Let it notice be issued, returnable by 4 weeks. 3 K Gogoi, for all extra copies. Serve him by today.
My lord, I will
Otherwise, there will be all it is.
the pendency of the it shall not be a bar, my lord. Otherwise,
Pendency shall not be a bar for consideration of the case of the petitioner.
hello.
Yes.
But if the petitioner is against the order of blacklisting, the facts are that the petitioner is a 35-year-old company, your lordship, is involved in the business of operation and maintenance of gas compression stations, your lordship. So it entered into an agreement with the ONGC for operating and managing a gas compression station at Baskandi, your lordship, in Kachar. So that contract, your lordship, commenced from 16/10/2019. One of the terms of the contract, your lordship, was that the contractor, your lordship, had to provide group health insurance, your lordship, to the employees employed in the station. Now, the insurance policy was provided, your lordship. Now, because our head office is in Mumbai, your lordship, there was a demand from the employees in Silchar that the policies should be managed locally, because otherwise making claims becomes very cumbersome. So we took a decision to have the policies managed locally. So the policy from 1/11/2021 to 31/10/2022 was all right. Then the next policy was due to commence from 1/11/2022 to 31/10/2022. Our local contractual employee, he made the policy, gave us a copy, which we furnished to ONGC. Later on, we found, your lordship, that employee, your lordship, had manipulated the date. Since the earlier policy had expired on 31/10/2022, the new policy should have started from 1/11/2022. That was what was reflected in the policy given to us. But instead of 1/11/2022, the date was 2/12/2022, your lordship. He had manipulated the date. There was a difference of 1 month. We informed that to the ONGC that there is a difference of 1 month in the policy. This is the actual policy. That information was given by us.
And in fact, there was one claim made by an employee, your lordship, during that 1 month period. All the medical bills of that employee we have paid, and we have received, the receipts are enclosed, your lordship. After the information was given to ONGC, suddenly on 5/10/2023, we get a show cause invoking the terms of the tender, which is usually for the tender process, that you have submitted forged documents, you will be blacklisted. We responded saying that the clause you are invoking is only for use in the tender process. And besides that also, we have made good any loss that would have been any claim against ONGC. And there was only a difference of 1 month, which has been taken care of. Otherwise, the main work, there was no problem. The reply we submitted on 26/10/2023. ONGC did not take any action. In the meantime,
No, the so cause was with regard to the existing contract
with regard to the existing contract
that you had given forged.
forged document,
Okay, we had replied to that.
we replied on
There-
26/10/2023, saying that there was this, we admitted because we had given volunteer information.
Okay, yes.
Then on 26/10/2023, did not take any action. Now our contract expired, your lordship. This work, it expired on 31st of November 2023.
Hmm.
So that work came up for retender. While that tender process was going on, suddenly on the 9th of this month, your lordship, a blacklisting order has been issued. Now that order, your lordship, is prima facie bad on 3 grounds. Firstly, on the doctrine of proportionality, that for such a small mistake, that too when information has been volunteered by us, it should not have been done. Secondly, your lordship, as per the law laid down in Kulja Industries, your lordship, a hearing is now mandatory before an order of blacklisting is passed. No hearing was granted to us. And the order reflects, your lordship, that the authorities had relied on some inquiry report. The inquiry report was also not furnished.
No, were you given an opportunity before blacklisting?
We were given a show cause notice.
No, that was in respect of while the contract was in existence.
Yes.
That was not for blacklisting.
That was for blacklisting.
Was it for blacklisting?
No, it was for blacklisting.
It was for blacklisting.
It was for blacklisting.
Let us see the notice.
Yes. The notice, your lordship, will find at page number 141.
Yes, please.
To Messrs. So-and-so, reference contract number so-and-so dated 16/10/2019. You are hereby required to show cause in writing within 15 days from the date hereof as to why business dealings with your firm should not be placed in the banning list and be debarred from entering into contracts with ONGC for the following reasons. With reference to the contract mentioned
But,
above.
Mr. Pathak, we have read this 510, but you say that your contract was valid up to 31/11/2023.
2023, your lordship.
And prior to the expiry of the contract in question, this notice was issued.
Yes, sir.
Was any action taken to cancel your contract?
No, yeah. We concluded the contract.
There was no action
No
taken.
action.
Okay, is there anything you want to participate in this?
No, your lordship, we have already been technically disqualified. So because
Yes, sir,
the
okay.
ramification is that in all tenders across the country now we'll be disqualified.
Now, is there any contract on the pipeline that you are
In
interested?
this tender, your lordship, the price bids have not been opened yet. So perhaps if the.
No, you have technically been disqualified
No,
because of this.
Because of this, your lordship.
Okay.
Because of this. Because in fact, the technical disqualification and the blacklisting order are of the same date.
Okay, heard. Sri K.P. Pathak, learned counsel for the petitioner. Full stop. The petitioner claims to be an experienced contractor in the field of maintenance of gas compression system. Station. Full stop. The petitioner was duly handed over the work of gas compression station at Baskandi.
South Baskandi,
the district of Kachar. Wide contract dated 16/10/2019 for a period of 5 years.
3 years.
3 years. Full stop. It is submitted that in connection with a particular document pertaining to group insurance policy, a particular employee of the petitioner had done some manipulation which on detection was duly informed to the ONGC by the petitioner. And the same was also rectified, full stop. However, comma, a show cause notice was issued on 5/10/2023 as to why the petitioner should not be blacklisted. Full stop. The said notice was replied to by the petitioner on 26/10/2023 and subsequently, comma, on 31/11/2023, comma, the term of the contract had also come to an end. Full stop. It has been specifically submitted that no action, comma, whatsoever was taken with regard to the contract in question dated 16/10/2019. Full stop. Para. So far as the ONGC, the respondent ONGC has subsequently notified the work to be done for the subsequent period, and the petitioner had participated in the same. Full stop. However, comma, by the impugned order dated 9/1/2024, the offer of the petitioner has been rejected on technical ground based on the reason that the petitioner has been blacklisted. Full stop. It is, however, submitted that the order of blacklisting is of the same date.
Yes.
That is 9/1/2024. Full stop.
Is annexure P here at page one.
Para. Para Sri Pathak, the learned counsel submits that apart from the work in which the petitioner has submitted its bid, comma, there are other works also in which the petitioner is interested and
has already participated
and had participated. Full stop. Para. Let notice be issued. Returnable on returnable on when? When is the date of financial opening?
Those tenders, your lordship.
This one. This.
No date has been fixed.
Returnable on 29th will not get the time. When this is there a standing council? No.
No standing.
On 5th of February 2024, that steps for service of notice be taken by registered post with ED steps within a week. Full stop. Heard the learned counsel on the interim prayer. Full stop. It is submitted that so far as the present work in which the petitioner had participated is concerned, comma, the financial evaluation is yet to be done. Full stop. In the interest of justice and balancing the equities, it is provided that till the next date fixed, comma, the outcome of the financial evaluation, the exercise of financial evaluation.
I'm sorry to interrupt. Because I have not assailed that process, that tender process at all, your lord. The challenge is only limited to the blacklisting order.
Understood. But you are interested, you have participated.
We have participated, but
Aren't you interested in this job?
Because the blacklisting order itself is not stayed, your lordship. We'll have to face consequences all across the country, your lordship.
Blacklisting, we may not be inclined to stay.
Because prima facie, your lordship,
Per se cannot without hearing. But we'll protect your interests insofar as this work is concerned.
Lordship, at least
we may not be disqualified. No coercive action will be taken pursuant to this blacklisting order. Your Lordship.
Oh, that is the.
By the ONGC, because Your Lordship, what happens is tenders across the country, prima facie, we are not given a hearing and the report was not given to us. That is an admitted fact, Your Lordship.
No, that so-called was there. It was specifically on so.
Bulja Industries says that a hearing also has to be given, Your Lordship.
These are debatable. You see Gurkha.
Suppose I am not challenging. Your
You
Lordship.
see Eurasian chemicals and
Yes.
equipments. You see Raghunath Thakur.
But natural justice,
The
even the
you
inquiry
have been
report was
given an opportunity, you've given a show cause. And for a blacklisting, more than that, in a given case, maybe, yes. It depends on the facts.
some protection regarding the blacklisting order, Your Lordship,
And,
because
and must stay difficult. We'll protect your interest in this work is concerned. Till the next date fix, no exercise of financial evaluation be carried out. Full stop. Para. The petitioner is also given liberty to renew his prayer for interim orders so far as other works are concerned on the next returnable date. Full stop. Para. It is also provided that since this order, interim order is passed ex parte, the respondents would be at liberty to come up for modification, alteration, if so advised. What is the date of the tender which you had NIT which you have participated?
the date is it is ONGC tender number SLC. It is at page number 148. Your Lordship.
Date
It is 38 2023.
38 बाद वाला 38 लिख लीजिए. Have published the fresh tender जो है 38/2023 बाद वाला list जिसमें उनको technically ये किया where he has been held to be technically disqualified. 38/2023.
Tender number is at page number 148.
Okay, next. But you take steps immediately.
Yes.
16.
My lord, in this case, the petitioner was settled with the part 5 of wholesale vegetable market in the Borpeta Road Police Station, Borpeta Road Municipal Board, Lordship. And it was settled on the 31st day of March 2023.
Okay.
And
For how many years? 1 year?
for the 1 year, with effect from the 1st April 2023 to 31st day of March 2024.
Okay.
And accordingly, I have deposited the kiss money and the security deposit, which covered around 18,42,890 rupees.
Okay. Now what is your grievance?
Lordship, our grievance is that after settlement of the market, after 1 year, one public road was constructed through my market area. And accordingly, the market was congested. I am facing the difficulties to collect the tools from our vendors.
What kind of public road?
Lordship, that the public pathway was constructed through the market area to meet the traffic congestion,
Okay.
which was permitted by the municipal board.
Okay.
And we are facing the difficulties to collect the tool. We immediately reported to the chairman of the municipal board to look into our grievances. They have not taken any decisions. We filed several representations before the authority. And they asked me to deposit the second piece money, and accordingly, which also I have deposited on the July, on 13 October 2023, page 45. And hereafter, they again asked me to deposit the third piece money, which is issued a notice, page 49, and
Who will issue notice?
And Lordship, may I just pray, Lordship?
Will not stay the tender notice of 1/1/2024.
Lordship, may I
You
just-
participate if you want,
Lordship, may
but without prejudice to your rights.
Yes, Lordship, may I just pray, Lordship, that tender notice will be effective from 31st day of 1st April 2024. I may be permitted to submit the detailed representations before the authority, and they will look into my grievance prior to the date.
We'll give you liberty. We'll not pass any directions for consideration. You will be at liberty to heard Sri H. Bajberwa, learned counsel for the petitioner. Full stop. It is the case of the petitioner that he was settled with the within inverted comma part 5, Roman 5 of wholesale vegetable market of the Borpeta Road Municipal Board for the period 1/4/2023 to 31/3/2024. Full stop. However, comma, within a short time of taking over the market, comma, a public road has been constructed through the market to remove traffic congestion, which however caused immense prejudice and loss to the petitioner insofar as the aspect of collection of tolls is concerned. Full stop. The petitioner had approached the authorities with his grievance, which however did not yield any results. Full stop para. It is also submitted that in the meantime, a tender notice has been issued on 1/1/2024 for the tenure starting from 1/4/2024 onwards on expiry of the term of the petitioner. Full stop para. That notice be issued, returnable on 7th of February 2024. Sri G. Bukolia Learned State Council accepts notice on behalf of respondent numbers 1,
2 and 3.
1, 2, and 3. What about 5?
5 also municipal notice should go.
1, 2, and 3. Let extra copies, huh? Right today during the course of the day. Let steps be taken for service of notice on the respondent numbers 4 and 5 be taken by registered posted AD. Steps within a week. Para. 3. Besbura prays for an interim order. Full stop. Considering the facts and circumstances, comma, though this court is not inclined to pass any blanket interim order restraining the new tender process, comma, the petitioner would be at liberty to submit a detailed representation to the appropriate authorities, and pendency of this writ petition shall not be a bar for consideration of the same. Full stop. It is further provided that without prejudice to his rights and interests, comma, the petitioner, rights and interests raised in this petition, comma, the petitioner may also participate in the fresh tender process.
Lordship, may I just say, Lordship, that without the leave of this court, Lordship, the part 5 market has not been settled with the other party, Lordship.
Sorry.
Only the part 5 wholesale vegetable market. Let's fix the matter on February, Lordship.
Yes, we have said 7 February.
7 much clear.
Yes.
Yes, but the petitioner has been maintaining a bank account with Eco Bank, my savings bank account. My lord. And thereafter, my lord, his salary has also been deposited in the said account, my lord. And your lordship will find house loan was also availed, my lord, by him. And lordship will find page 13 is the statement. And out of that bank account, the installment, my lord, EMI was also deducting, my lord. Page lordship will find up to August, page 16, 17.
Okay, we'll issue notice.
Notice, my lord, and also, my lord, my only prayer is that, my lord, only I have to pay 15,000 of two account, from two loan account. And other account, my lord, recently, my salary has been deposited 38,000, my lord. Deducting that rest amount, I may be allowed to put the money, because there is,
That is your version. Without knowing their version, how can we pass an interim order?
and all lordship will find, my lord, there is a,
You take steps, we'll fix a date.
page 24, my lord, page 24.
As soon as
lordship will
possible.
say.
Heard 3 as not learned counsel for the petitioner, who is aggrieved by. Is there any order passed of freezing your account?
No, my lord, no order, my lord, nothing, my lord. Only they have hold up, my lord.
Who is aggrieved
I was not allowed to
by
operate, my
the
lord.
action of the respondent bank in not allowing the petitioner to operate his. Is it a savings bank account?
Yes, my lord,
Is it
savings account.
SB account number? Yes, sir, huh? SB account.
SB account.
SB account, full stop. Para. The petitioner is maintaining an SB account number so and so in the UCO Bank, Saria Tali branch in the district of Nalbari. And it is apprehended that in respect of certain home loans,
Yes, ma'am.
the aforesaid action has been taken. Full stop. Para. Let notice be issued, returnable on 5th of February 2024.
Lordship may peruse page 23, my lord. There is a letter from the bank that, my lord, there is some overdue of the bank account, page 23.
Yes.
And out of that, my lord, they have hold up my account. My salary I cannot draw. They are entitled to deduct my amount, my lord. So, my lord, after deducting that amount, I may be operate or 50% or whatever may be, my lord.
You will have in the returnable debt. This is 13,000 something and 18,000. Why don't you pay? These are minor amounts. Returnable on 5th of February 2024. Less steps be taken for service of notice.
Maybe on 29, my lord, because
29th. Can you serve Dusty?
just taken, sir, my lord.
You can serve, okay, 29th. Huh? 29th. That notice be served upon the less steps be taken for service of notice upon the respondent numbers. Irrigation is also there, 1 and 2 by registered post with AD.
1 and 2, my lord.
Steps within a week. Irrigation department, who is the sending council? Anupadhyay. Is he there in the court? Or his junior, anyone? Okay, Sri Anupadhyay, understanding council accepts notice on behalf of respondent number 3. Para. 3 Nas. The learned council prays for liberty to serve Dusty upon the respondent numbers 1 and 2.
Not 1, my lord, 2, my lord. 1 is my lord, registered post, my lord. 1 is at Kolkata, my lord, head office.
Oh, to respondent number 2. Full stop. Such accordingly, the petitioner is allowed to serve Dusty upon the said respondent number 2, which has, however, is required to be routed through the registry of this court, and the notice accompanying the Dusty service is to clearly reflect the next date. Full stop. The petitioner is also required to file an affidavit in proof of such Dusty service.
Lord.
Para, on the next date, this court, the petitioner may renew his interim prayer.
Apply.
22.
May I please? My lord, in this case, my lord, opposite party respondent, petitioner has filed objection, my lord, in the IA, my lord.
Sir, we have filed our.
Which is not on record, my lord. May I pray for?
IA for what?
For modification of the interim order, my lord.
Okay, you are the writ petitioner.
Yes.
You want some time for taking instructions.
I pray for on 24, my lord.
24.
24 is typically my 25th.
25. We pray for 25.
You are also as Thakur.
My lord, no, on behalf of S. Thakur, Mr. D. Gogol.
No, Mr. Thakur is for whom?
For the applicant, my lord.
Okay, you're for the applicant.
Yes, my lord.
Sri D. Gogol, learned counsel for the applicant, respond number?
Respondent 5, my lord.
5 submits that the objection affidavit has been filed by the opposite party writ petitioner only yesterday.
Yes.
Full stop. He accordingly prays for some time to obtain instructions. Full stop. Para. List on. Also heard Sri A. Boro.
Yep.
learned counsel for the opposite party writ petitioner as well as MSA guy and learned CGC. Para, as agreed to by the parties, list on
25.
20,
25.
25-1.
Madam.
Public.
23 and 24.
The non-payment of contractual bill, earlier this one series of question, repetition were disposed of. I have enacted that order also,
But in this matter, these are FMP, flood management program scheme lordship. There is central and state government sharing of the funds. But if the state government part has been paid, only the central government is left. If lordship,
Mr. Architect, are you appearing?
Yep.
There was a check from the Honorable Court. And this budget was to be submitted to the central government and on receipt of that, also release the amount. I think that amount has been released. And if he is covered under those schemes, definitely,
You get the instructions.
I will.
Hearts free, Kolita. Learned. NK Kolita, learned counsel for the, both the matters, same, Mr. Kolita?
Yes.
Learned counsel for the petitioners in these cases. Also heard Sri C. Sharma. Learned standing counsel. Learned counsel appearing on instruction of Sri R.M. Das. For the respond number? For the Water Resource Department.
I am for one and four.
Who submits that so far as the state's share, state's, what do you call? Is it share? Share is concerned, comma, that has been paid. And only the part by the central government was required to be paid, full stop. Sri R.K.D. Chaudhary, then DY and Deputy SGI, who is present in the court, has however informed that as per instructions received by him, comma, the share of the central government has also been paid in the meantime, full stop. He, however, submits that some time may be granted to enable him to take concrete instructions, full stop. Para.
That in fact was transferred to the finance department, then the concerned department of the state government will release.
Contrary instructions regarding the further action taken. Full stop. Para. List when?
Worship will give it 3 weeks.
List on, we'll fix a date. On, we'll give you adequate time. We have it on 9th of February.
If the lordship, if that pertains to appointment of arbitrator.
Yes.
With regard to the project in question, I have already completed more than 95% of the work. And there is some delay for the remaining part of the work. And then for that, lordship, notice was issued. And subsequently, my work was terminated, lordship. The notice was, lordship, foreclosure notice, page number 285.
No, you are here for appointment.
Appointment of arbitrator.
You are challenging the termination.
No, I'm not challenging
No,
termination.
the dispute is with regard to termination or what?
No, I have no dispute with regard to.
Then what is the dispute?
No, I'm not only lordship, I have lordship, presented my claim lordship subsequent to the termination. And that claim is not settled, then I invoke the arbitration clause. Notice has been issued, 30 days period has been over. No name has been suggested. That is why I am before the.
No, that we have understood. We have section 11 petition, but ultimately it emanates to the order of termination. That is the outcome by which you have raised the uh, claims before.
Yes, sir.
Yes, why don't you appoint an arbitrator?
Lordship, there's no difficulty in appointing an arbitrator, Lordship.
Do you have any named arbitrator?
Lordship, as per the arbitration agreement, Lordship, there is a panel of arbitrators.
Correct.
And that has been agreed by him in the contract. So, this I am having Lordship can appoint.
Yes.
from there.
Mr. Bora?
From that is because these are perhaps the officers of, these are lost, these, if my friend is agree, these are officers from different departments. If he was. an
Mr. Bora,
officer from another
Mr. Bora, you are free to,
He can
no,
do
no,
that.
you are free to raise your objections with regard to, because this matter is before the Supreme Court, larger bench. If the in-house officers can be arbitrators or not, but otherwise, if you are agreeing in principle with such appointment, you can give your consent, we can appoint any one of your choice.
He can, this is a, of the garrison engineer, Lordship. He can have any officer apart from garrison. So far as officers part is concerned, I have objection because the partiality of the appointment arbitrator.
No, those submission you need not make here. It has been, or it will be made in the appropriate court, it will be decided. We'll go by that.
But with regard to the issue before the Supreme Court, that issue is not whether the retired officer or a serving officer can be appointed as the arbitrator or not. The issue is whether the appointing authority, who is ineligible in view of the section 12(5), can refer the matter to arbitrator or not. That was the issue. The government servant or retired employee, that is not the issue before the Supreme Court. As per Tantia construction order.
No, if you not go to the Supreme Court, you have the act, you go to the schedule, I think schedule 5 or 7.
Yes, sir.
What was it? 5?
5.
Schedule 7, Your Lordships.
Schedule 7.
It's the Arbitration Act.
And so far as Lordship.
No, in that case, we can hear your matter on a day.
Yes,
later
sir,
date.
it can be hard, Lord.
But we'll not take a call when the matter is present before the Honorable Supreme Court. How can we? Let there be a pronouncement, then we'll follow that. When is the next date? Any idea?
The next date, last quarter was.
Your Lordship, if I may intervene, this matter was listed last time before the Supreme Court on 13 September 2023. And nothing has happened ever since then. The government on record basically said that a consultative process has now begun within the government and certain amendments will be brought to the Arbitration Act. But ever since 13 September 2023, no date has been fixed and this matter has not moved at all. As a result of which parties are severely facing problems because of this.
But so far as the issue that was referred before the larger bench in the Tantia construction case, may I place that order, Lordship? The issue is very
Now you tell us, will it be proper for us to embark on this issue and this?
Because Lordship, there is no variety. Because the issue is very different. What has been referred.
Mr. Devchaudhary, are you otherwise agreeable for any other arbitrator?
Lordship,
We may not record your consent, but just. If then in that case, we can resolve the conflict, whatever dispute right now without even going into that aspect.
My client's instruction is Lordship, there's a dispute. And Lordship, as per Lordship, section 11, subsection 5, Lordship, respondent authority has lost his right to appoint the arbitrator. Of the. If your Lordship, for a moment.
Yes, doesn't matter.
And of the record, Lordship, I would agree, Lordship, if there is a retired judge of this High Court, I not have. Yes, sir. I'm agreeable to that. Maybe if I may propose, Justice B.K. Sharma.
Let us end this then. We'll not straight away record your consent. We'll say that you'd have the as per instructions, you'd like to have an arbitrator from the panel.
Yeah, I'm agreeable with that.
Heard. 3B Bora, learned counsel for the petitioner. Whereas the respondent, how many respondents?
One respondent.
Respondent is represented by Sri R.K.D. Chaudhary, the learned deputy SGI. Full stop. Para. The instant application has been made under section 11 of the Arbitration and Conciliation Act, 1996 for appointment of an arbitrator. Full stop. Sri Bora has referred to clause 70 of the GCC which provides for adjudication, public resolution of a dispute by way of arbitration. Full stop. He has also submitted that claims have been raised and the matter is pending only at the stage of such appointment. Full stop. Para. Sri R.K.D. Chaudhary, learned DSGI, does not oppose the prayer for appointment of arbitrator in principle, as there is a contractual provision for such resolution of disputes. Full stop. He, however, submits that the arbitrator so appointed is to be from the empaneled list. Full stop. This court has been apprised that the issue of having an arbitrator who has a connection with the department is pending consideration before a larger bench of the Honorable Supreme Court. Full stop. Para. Be that as it may, comma, this court is of the view that without even going into that aspect of the matter, comma, interest of justice would be served if a neutral arbitrator is appointed, more so when the very objective of the Act of 1996 is to have a speedy and efficacious resolution of disputes in contractual matters. Full stop. Para. In that view of the matter, comma, this court appoints Sri B.K. Sharma, as Justice B.K. Sharma, within bracket retired, comma, Guwahati High Court, to be the arbitrator to adjudicate the dispute between the parties. Full stop. The parties may accordingly approach the learned arbitrator within a period of 10 days from today, from which date, comma, the matter would be taken up for consideration as per the convenience of the learned arbitrator.
First.
We are 10 to 15 days
15 days.
before. Sarah, the registry is also additionally directed to send a copy of this order, to communicate a copy of this order to the learned arbitrator to enable him to do the needful.
Your Lordship, I have an item 26, identical matter. Would you quickly like to hear it before lunch, if it's okay with your Lordships?
Lunch, 1 o'clock is over. No?
All right, all right.
You should stay alert at that time. What is
Sorry,
this? Must have already signed, you do not know. Who was in 22? Yes.
26. Your Lordships, I appear for item number 26 for the petitioners. At the
Yes.
outset, thank you so much for allowing me to appear virtually. Your Lordships has already had the benefit of hearing item 25. I stand on a very similar footing, Your Lordships. Even in my case, the appointment of the arbitrator is being stalled because of this one particular judgment that the counsel for respondent has cited. And as Your Lordships is aware, this judgment is pending consideration before a constitution bench of the Supreme Court. The difference in my case, however, Lordships, is I don't think the respondent maybe in tandem may give their consent. Therefore, I'm going to convince Your Lordship.
Yes, who's for the respondents?
25 is not similar with the 26. 25 is the matter pertaining to the Lordship, border roads organization Lordship. Here 26 is the in respect to Indian Railway Lordship.
Your Lordship, the arbitration clause is right. The similarity here, since I hold the floor, if I may, if I may present my arguments, the arbitration clause is very similar to the one that Your Lordship has seen.
No, there is a difference between the railways case and other cases.
Sir,
So far
Your
as
Lordship-
railways case is concerned, the requirement for referring to the larger bench is because of a case passed in a railways case.
Correct. Your Lordship is absolutely right on that. But Your Lordships, my submission here is that there are judgments of the Delhi High Court and the Supreme Court which have gone ahead and appointed arbitrators in the presence of this judgment, which is currently pending which is currently pending adjudication before the Supreme Court. If I may refer one judgment which is already on Your Lordship's file, the Delhi High Court, as recently as September of 2023, in a very similar fact situation, has proceeded with the appointment of the arbitrator in the presence of this particular judgment, remaining in the field as a thorn. If Your Lordships has that judgment, I may kindly direct Your Lordships to directly come to paragraph 19 at page 11. This is a case, Your Lordships, where the arbitration clause is very similar to the clause at hand. Herein, the Delhi High Court has held in paragraph 19, and I quote, although the correctness of the judgment of the Supreme Court in Core is the case, Your Lordship, which has been referred to a constitution bench, was doubted by coordinate benches of the Supreme Court in the case of Tantia Constructions and JSW Steel, the operation of the said judgment has not yet been stayed, and therefore it continues to hold the field, as also observed by a coordinate bench.
Okay, just a minute. Mr. Gogoi, in principle, are you opposed to having an independent arbitrator?
Lordships, regarding that part, Lordship, otherwise also, Lordship, we are stand by that, Lordship. Similarly situated matter is pending for honorable. My Lord, I kindly present the order of honorable court on 15-9, Lord. It not
This court.
It is not a single case, Lord. 15-9-2020, Lord. My Lord, I kindly present the order.
Your Lordships, it is a matter of fact that this honorable court.
Just a minute.
15-9-20, Lord. Not only this, Lord, a series of matters are pending, Lordship, as because the constitutional bench is, Lordship, and as per last order, Lordship, the matter was picked on 22/11/2023 before the honorable Supreme Court, Lordship. Due to some, Lordship, changes of the benches, Lordship, this matter was not taken up.
Your Lordship,
Okay, we'll grant another opportunity. On the next date, then we may also take into consideration certain cases which have been disposed of by the Delhi High Court, which.
Your Lordship, my only humble submission is this matter has been now pending for the past 1.5 years. My clients have been completely crippled financially because of the delay in the commencement of the arbitration. The Railways has absolutely zero case on merits, and this is precisely where they want to seek refuge.
That is okay, but there are other cases.
Your Lordship, I will
More
just
than,
submit.
Lordship, 20 arbitration matters, similar issues is pending before this honorable court.
Your Lordship, this is
Even I have
what the learned
matters.
counsel is saying is correct. I'm not denying that. All I'm saying is, Your Lordship today has precedent before you to go ahead and appoint the arbitrator.
No, Mr. Chaudhary, in the other case, we had asked for a consent. He's given tacit consent. Though we have not recorded the consent, but here, since learned counsel is saying that he would go by the right guidelines, and there is an order which.
I understand that, Your Lordships, but I am attempting.
15-9 in your proceedings, there is an order that this is listed after the decision of the Supreme Court.
But Your Lordship,
based on such order, passing an order on the very next date may not be proper.
I
But
understand.
Definitely consider.
I understand, Your Lordships.
Heard Sri R. Chaudhary, learned counsel, who has appeared by virtual mode for the petitioner. Full stop. Sri K. Gogoi, learned CGC, is present for the respondent railways. Full stop. Reference, though Sri Chaudhary, learned counsel, has submitted that the mere fact of reference of the issue before a larger bench without an interim order may not be an embargo for this court to go ahead with the appointment of an arbitrator, appointment of an independent arbitrator, Sri Gogoi, the learned counsel for the respondent, has referred to the earlier order dated 15-9-2023, passed in this case, as per which, the matter was to be listed after the decision of the Honorable Supreme Court in the case which has been referred, in the case which is currently before a larger bench. Full stop para. In view of the above, a further adjournment is granted. Directing listing of this matter on, we can fix a date, Mr. Chaudhary.
Your Lordship, the only problem is we don't know, nobody knows when this matter is going to be listed before the Constitution bench.
That is okay, but
As per the as far
And-
as.
We are giving you the liberty to have a date. If you want, you can have a date.
Your
Otherwise,
lordships may please kindly be, then in that case, your lordships may fix this matter in the next,
Lordship,
in
as
the
per
next
the
2
information
weeks.
received from
If
the
if
Lordship,
nothing happens in the
General
next 2
Office,
weeks,
Lordship,
your
it
lordships
will
may
be
give me.
listed on the midweek of the February, Lordship. Is a possibilities there for listing because there are just some changes of banks also after retirement of the Honorable Justice of the Supreme Court. in
Your
the
lordships, and precisely, this is precisely why we may not have to wait. The more we wait for this matter, your lordships.
okay, now no point arguing. We have passed the order, Mr. Chaudhary, on 5th of February.
Instead of fifth,
Obliged,
Lordship, it will be
obliged.
after 15 or then it will be come up.
Let us try on
Lordship,
5th.
Lordship.
Fifth is fine, your lordships, obliged.
Okay. 27, yes.
To build this matter, we have filed our affidavit. This is also related to the flood management program. And here also petitioner have not made Jal Shakti a party, Ministry of Jal Shakti.
Okay.
may kindly bear page number 15, Lordship.
15.
Lordship. That is the liability statement and the order were passed in the year 2012, Lordship. Work order were passed in the 2012 and 2013, and they already paid almost a small amount is left, Lordship, it's 7 lakhs something. Lordship may kindly dispose of the matter, directing them to release this amount.
If that would help.
They already paid, Lordship.
That was
Now, will they be in a position to pay the outstanding bill?
They should, this is 2012 matter, Lordship.
He is saying that it is under a scheme where the central government instrumentality is
In the
also
work
involved.
order does not mention anything about that. It's there, they admitted their liability. They should pay our money, Lordship. And the petitioners, their contractor and their.
Chaudhary, this has been disclosed during the pendency of these proceedings. Are you doubting what your colleague is saying? If we pass an order, will it help you? You cannot enforce the order with who's against somebody who's not there before the proceedings, in this proceeding before this court. But how much is the dues now, remaining balance?
Remaining is 7 lakhs. Lordship, petitioner number 1, 7 lakhs. And petitioner number 2 is 8,64,000, Lordship. Already they paid 23,91,000. They already paid, Lordship.
That was the state share that. we
It's
have
just a
released.
small amount, Lordship.
But let them make Jal Shakti a party.
What is your stand in the affidavit?
So, they have completed the work, Lordship. Our stand is that the state share has been released. On the central share is pending, Lordship. So,
Where have you stated?
Lordship, paragraph number 7.
Of the affidavit of 1512 or next affidavit?
Lordship, affidavit filed by respondent number 2.
991,
Yes, sir.
day before yesterday.
No, Lordship, page number 27, running page 27.
Yes, it filed on 9/1, 2024. Which paragraph?
Lordship, paragraph number 7.
7. What have you stated?
If Lordship comes, Lordship, I will read the whole paragraph. That before adverting to the pairwise reply of the aforesaid writ petition, the deponent takes to raise preliminary objection regarding the maintenance of the writ petition on the ground of non-joinder of necessary parties. In this regard, the deponent takes to state that the work order was allotted to the petitioner against the scheme RS2P dike along both banks of Popili River from Soraihaki to Tuklatup LB, Bosundhara to Killing Popili Junction LB and Saparmukh to Atpuri Amsoy PWD Road RB, including anti-erosion measures at different reaches, had various work orders. It is pertinent to mention here that the state scheme is under FMP, Flood Management Program.
Have you gone through this, madam? Specific plea has been taken towards the end of.
At the time of, they came up with this thing, new, Lordship. But this is 2012 matter, Lordship. They have kept the bill pending.
Now, how do you overcome this? These are statement of facts.
Already work has been completed in the year 2013, Lordship.
That we have understood.
The petitioner, Lordship, he borrowed money from market and still he have to prepay.
That we have understood, but it's a writ court. And here they have said that their part, they have already released. The remaining part is of the central government, Ministry of Jal Shakti. And this is a preliminary ground he has taken of objection. And this objection is okay, but aren't funds available with you to make the payment?
No, Lordship.
Where have you stated?
Lordship, we have stated that the fund which was
Yes, yet to be received by the central government.
Lordship, they will obtain the fund. We can't do anything for it. They may be directed to get a fund for it.
Where is the work order?
Lordship, I have annexed only the liability statement.
Oh, that you have to, if you want an order of that nature.
Work
give the
order
work-
number is there, Lordship.
No, work order. Who has issued this work order?
Executive engineer, Lordship.
Where?
It's in the liability statement, page 14, it's
No,
written.
no, we want to have a look at the work order. What is the nature of liability? Who will share? If on the face of the
Page
work, if on the face of the work order, there is no reference to any Jal Shakti, then probably
It's not there, Lordship. May you kindly peruse page 15, Lordship.
1.5.
Yes, Lordship.
Yes.
Liability.
Liability
No, not
statement
this.
is,
We want to have a look at the work order.
page
Scheme.
16 is there, Lordship.
16 is what? Running account bill.
Yes, Lordship, that's a bill, Lordship. After completing the work, they submitted the bill, Lordship.
This will not do.
Page 20 is also there, Lordship.
You try to have get a copy of the work order. I heard MS K.K. Chaudhary, Learned Counsel for the petitioner. Also heard Sri Sharma, Learned Counsel appearing for the Water Resource Department. Full stop. Sri Sharma, comma, the Learned Standing Counsel, comma, by referring to the two affidavits filed on behalf of the department has submitted that so far as the share of the state government is concerned has been paid to the petitioner and the balance period pertains to the share of the central government, namely the Jal Shakti, Ministry of Jal Shakti, in the Ministry of Jal Shakti, namely in the Ministry of Jal Shakti. Full stop, para. He has also raised the objection of non-joinder of necessary party. Full stop, para.
Lordship, I
Para.
will be allowed to make them a party.
Ms. Chaudhary, the Learned Counsel at this stage submits that she may be allowed to make the said ministry a party respondent and also annex copy of the work order by way of an additional affidavit, work order, and also bring on record the work order in question. Full stop, para. List after 3 weeks.
Lordship. Lordship, similar matter, or item 29 is similar matter, Lordship.
Same objection
Same,
they have
same.
taken.
Yes.
Oh. 2 affidavits you have filed in that case also. 2 affidavits.
Lordship, they also they filed affidavit.
2.
One, I think.
Here they have
One,
filed 2.
There is one.
Lordship, a date may be fixed, Lordship.
3 weeks. Can you file? When can you file?
February.
As paid for list on 7th of February. Is it okay? Can you do it before that?
No, Lordship,
9th,
second week, okay.
9th of February?
Oh. Oh, please.
Public.
Item 28.
Your Lordship, in the morning I prayed for adjournment. We have informed the PAC department.
Madam,
Kindly fix
what is your difficulty, madam?
Mr. S. Sharma, the conducting counsel is unwell and the file is also with him.
Okay, it is submitted that Sri S. Sharma, Learned Counsel, conducting this case for the petitioner is unwell. Para also heard MS M. Kolita, Learned Counsel representing the Public Health Engineering Department, as well as Finance, anyone for the Finance Department? And R.M. Barua, Learned MS R.M. Barua, Learned Counsel representing the Finance Department. Para list after 2 weeks.
Lordship. Obliged.
Is there any interim order?
No, your Lordship.
Item 30.
Obliged, sir.
Wait, please, your lordship. Your lordship, just
Yeah, please, Lord. Yeah, I'm appearing on behalf of Miss S. Dunya, Lord, for respondent number 7, Lord. Last week, she has suffered a stroke, Lord. Is paralyzed. So I'm praying for adjournment.
Okay, don't worry, we'll give the adjournment. What is the matter?
Your lordship, it relates to settlement of market, your lordship. In spite of me having the a higher bid, your lordship, the matter has been settled in the name of private respondent number 9. Your lordship, my
One year.
1 year settlement.
Okay, you make some alternative arrangement, we'll grant you some time. As we are, what is your full name?
Mine, Sima Bunya, Lord. The counsel for the respondent number 9.
It is, though the Learned Counsel for the petitioner is present, comma, it is submitted that Miss S. Bhuya, Learned Counsel for respondent number 9, is unwell. And accordingly, the Learned Counsel representing her has prayed for some time. Full stop. Sri S. Datta, Learned Counsel for the PNRD is, Standing Counsel PNRD is present. Full stop. Para. List after 2 weeks.
4 weeks, Lord.
1 year market.
Your lordship, 1 year. Your lordship, my humble submission is that since the respondent number 9 submission may not be of that necessity, because your lordship, respondent number 9 is a private respondent, your lordship. And if the PNRD department is here with the record, your lordship may decide the matter.
We will fix the date. We'll have it, make some alternative arrangements. 1 year. Otherwise, you'd have granted more time. List on 2nd of February.
Can it be on 29th of January? No, more.
You have only one matter.
Your lordship, no, on 29th of January, I have matter regarding the same kind of matter, your lordship.
Second.
Item 31.
Mr. Khandalia does not take fish. So no order.
Lordship.
Do you take fish?
No,
Then how do you pay for fish orders?
the petitioner are taking, I am representing them also.
We only know the council.
Lordship.
Done.
No, not yet, but
Why?
today the final hearing took place today, Lord. Lord, basically, Lord, today an inspection report was received. That is against him, Lord. That is why the commissioner,
Lordship, at 1:30, my client has been received with a WhatsApp message asking him to come at 3 for hearing. And he is out of station. He has just informed me over phone. Only thing is that they are delaying the matter, Lordship.
Let somebody represent him today. 3 o'clock.
I don't think because in a.
Where is he? Outside?
He is out
outside
of
the state?
Guwahati. He is out of Guwahati.
Then have it tomorrow or day after.
yes, Lord. But
Tomorrow, I think it's a holiday.
Tomorrow is a holiday, I think. And next 3 days are Bihu.
Otherwise, initially, Lordship, my permission was cancelled. Then by way of corrigendum, they have suspended me for a temporary period inspection representation was filed. They verified the matter. They have not filed the report, and the lease is only for a period of 1 year. And
No, not if that is a different aspect, not if initially it was
But
profit.
you had held a hearing, then why subsequent hearing is
No,
necessary?
that inspection report is against it. That is adverse to him. That is why before taking a decision, the authority wants to have a discussion with the petition. That is the only.
Heard Sri G. Khandelia, learned counsel for the petitioners, full stop para. Sri P. Nayak, learned standing counsel,
Yes.
GMC, has however submitted that he has instructions as per which, comma, the inspection done in the matter is has culminated in a report which may be against the petitioner, and therefore he was called for a further hearing. He has been called for a further hearing today. Full stop. Sri Khandelia, the learned counsel for the petitioner, however, submits that as per instructions received by him, comma, his client is out of station and would not be in a position to attend the hearing today. Full stop. Para. It appears that the hearing may be required to be deferred. Full stop. To facilitate such hearing and for the interest of justice, the matter is adjourned. Full stop. However, taking into consideration that the tenure of the settlement is for 1 year, comma, the next date list this case for consideration on
18 lot.
18th. This Bihu days, can you hold the hearing?
Not if, office will remain open on 7th, right? Office will have. High Court is opening on 18th.
on
Otherwise-
17th, they can have the hearing.
On 19th.
And on 17th, they
And
fix it.
try to instruct your officer to hold the hearing on 17th.
In the meantime, Lord.
Yes, because he appear today through somebody and pray for time.
If possible, we'll play. Otherwise, on 17th, we will, they may again give us a,
No, somebody has to be there and say that you are not.
Lordship,
Lord, if
they
it is not
communicated us
possible-
only at 1:50. Lordship,
Lord,
today.
if it is not possible for him for today, Lord, then let him convey a date, Lord, prior to 18, Lord.
17th, he has said.
Yes. Yes. Lord. It
Then
will
we
be
can
done.
make it a partner order.
Yes.
It will be done.
Your officers will be there, yes. তার উপর document change over has been called. Today is not in a position to has not in Guwahati. Under those circumstances, comma, and as agreed to by the parties, comma, let the hearing be held on 17/1/2024 and this case be listed for consideration on 19/1/2024.
Much.
Okay, next.
May I please, Your Lordship?
Yes.
My lord, in this case, petitioner before your lordship are the board, member of the board of directors of a cooperative society, my lord. My lord, pursuant to an order, annexure page 13, annexure 1, my lord. The license of the cooperative society was suspended.
What license? Fair price shop?
No, my lord, cooperative society, my lord.
Oh, cooperative society license.
License. my lord.
Registration.
Yes, ma'am, license, ma'am. It's license. Wholesale license was suspended.
Wholesale license.
Yes. PDS license.
PDS
Wholesale
license.
was suspended and tagged with another cooperative society by order dated, my lord, 10/1/2023, ma'am. Annexure 1, page 13, ma'am.
Suspended.
Suspended and
Okay.
tagged with a different society, ma'am, nearby society.
Yes.
And the suspension was preliminary on the ground that the secretary of the society has committed some illegalities with regards to PDS item. Thereafter, my lord,
Now here notice was issued on 15 and you've got instructions.
No, your lordship, instruction awaits, sir. Otherwise, your
Get the
lordship,
instructions.
my lord, what happened, my lord?
These matters we can dispose of.
My lord, in
Is
terms
it
of,
covered by the 1982 orders?
yes, what 82 orders, my case is that, my lordship, can you see last order, my lord? My case is that in terms of the section 15(2) of the 82 orders, Deputy Commissioner has not served any notice till date. And pursuant thereto, I have filed a representation before the Deputy Commissioner for consideration, my lord.
What was the date of suspension?
Suspension was 10/1/2021, 23,
23.
23, my lord.
But otherwise, your lordship, it is up to the deputy commissioner to consider also. The representation is also pending.
No, how do you continue a suspension for a period more than 90 days?
Yes.
Let me set the matter, lordship, in the reopening, lordship, otherwise someday, because lordship, our name is not shown, lordship, we have also missed the file. Whether some instruction may also come.
No, it's for him to get the instructions.
And Deputy Commissioner may dispose of my.
Okay, well, okay. Give you a chance. I have it on the reopening day.
Lordship.
Okay.
My
Three.
lord, our price to reflect the comment. Yeah, yeah.
Okay.
No, that's fine.
Heard 3 JMA Chaudhary, Learned Counsel, for the petitioner who is aggrieved by suspension of a PDS license. Full stop. Do notice was issued on 15/9/2023, comma. Instructions are yet to be received by the Learned Counsel, received by the Learned Counsel 3 G. Baudelaire, Standing Counsel of the Department, full stop. 3 para. No, actually, 3 K. Gogoi, Learned State Counsel, however, submits that since the cause list has not properly reflected their names, comma, another date may be fixed as some instruction might have been received. Full stop para. Considering the above submission, list this case on 19.
Lordship, one limited prayer measure. On 15/9, there is an observation in the order to the effect as to produce the instruction with regards to whether they have issued any shock cause notice in terms of subsection 2 of section 15. My lord, whether they have
that instruction,
my lord, they should produce on the next day.
You may kindly reflect our name.
Cause list to reflect the names of GSR. Item 33.
May it please your lordship. Lordship, in this matter, I am seeking resumption of operation of my boring water supply units. Lordship, it has been closed down without giving any notice by without giving any CISO memo. And after that, I filed a representation asking the question why it was closed down. And thereafter, they've given an impugned order. Lordship may find it at page number 29, annexure 4, whereby it is said that I'll have to seek permission from the Central Groundwater Board. Thereafter, I have sought that permission from the Central Groundwater Board, where it is said that I do not need that permission since the amount of water that I seek to extract is exempted. Lordship, even after that, it has not been opened.
In fact, my lord, there is an act, my lord, Assam Groundwater Control and Regulation Act. That under section 6, my lord, they have to take a permission from the either for domestic or for the commercial use. That permission had to be taken.
Even for domestic?
Even for domestic. But I have highlighted it.
What do you say, madam?
Lordship, we have permission for the commercial usage, Lordship. I have the valid license till 2024.
That is a trade license, they had taken it by online. Without informing that that permission has not been taken. You have to take it as per section 6, that act, you take a permission. Thereafter, you will get a trade license.
Where is the permission, madam?
Lordship, first of all, the first permission was of 2023. Lordship, may find it at page number 20. Lordship, this is the license which was valid till 31st of March.
Mr. Bora, you file an affidavit. You are raising a dispute with regard to the earlier license also. Have you otherwise got the
I have received
instruction?
my instruction.
Okay.
I'll file my affidavit.
Sorry, as Bora, I heard Miss N. Begum, Learned Counsel for the petitioner. Full stop. Also heard Sri as Bora, Standing Counsel. GMC, who submits that instructions have been received and he would like to file an affidavit in opposition. Full stop. He has also submitted that there are valid grounds to justify the impugned action. Full stop. Para. That such affidavit be filed, for which 3 weeks time is granted. We fix a date.
Lordship may file.
Tell us the date of your convenience.
It is second week of February.
List on 7th of February. Item 24.
Make to your lodge. Well, this matter relates to challenge to tender, particularly one particular clause by which all the existing tenderers of existing registered contractors are ousted from the competition. Now, my learned friend, he expressed urgency on the last date, and that is how the matter has come. There is an interim order that is still today.
Yes.
Now, my lord, the challenge made is to an NIT dated 24/8/2023, which your lordship will find at Annexure 3, page 27.
24/8/2003.
24/8/2023.
Page?
Page 27, Annexure 3. It has been issued by the Chief Engineer of the Assam Police Housing Corporation for construction across 16 districts of my lord, the quarters, so residential quarters.
Yes.
27, it starts. The clause by which the petitioners are aggrieved that your lordship will find at page 36.
LS means RCC, LS means
No, I'm okay.
what? Construction of RCC LS quarter means? Lower subordinate. Okay.
Clause 2.2.2.4.
Page?
Page 36.
Additional qualification.
Additional qualification. The contractor bidder should have experience of executing at least one building project of value of not less than 50% of the estimated cost during the last 7 years, ending the last date of the month previous to the one in which the tenders are invited. These works should have been executed either on EPC mode, this is where my lord the problem lies, or design and build mode, or the work was executed with in-house architectural firm of the contractor bidder having structural engineer and architect, or the work was executed by the bidder contractor by tie-up with an architectural firm having structural engineer and architect, have to submit proof of payment of the latest EPF, ECR, electronic challan and return with members' details, educational certificate and professional tax for the last 1 year. Intending bidder must not be placed in the negative list of the firms. This is may not be relevant. Now, my lord, this EPC mode, EPC, my lord, stands for engineering, procurement and construction. Now, these, my lord, all the members of the petitioner association, they are registered contractors. They have been doing this construction work in this department for the last 30-40 years without any complaint. My lord, the tenders, as your lordship knows, is procurement and construction, that is the normal mode. Now this engineering clause has been included in the EPC mode that requires that there has to be an architect or an engineer where this engineering designing etc. will be done. The normal procedure as has been followed till now, till the other day, EPC mode has been introduced only recently. And because of that, they do not have an architecture because they do not design it. The design is done by the authorities. On the basis of that design, the tenders are invited. Then other factors are there: construction, cost of construction, and materials, etc. Now this none of the registered members, registered contractors have this eligibility condition, and therefore all of them are debarred from participating. Now, my lord, my submission before your lordship will be that although this EPC mode has been, introduced, but the time has to be granted to these existing contractors so that, they can tie up with the architectural firm, which has been a requirement in the additional qualification, or the experience that has been required by this additional qualification that has to be dispensed with. This is arbitrary. And the parties which will now be able to participate, they will not be registered contractors, because the registration of the contractors is a requirement under the Assam Public Procurement Rules 2022 and the Act thereon. So anyone can now participate. So that has, affected the right of the parties, and they will be out of business, all these local contractors. Now, this notice, your lordship will find, this was, issued on 24/8/2023.
Yes.
Then it has been extended, last then extended from time to time. And this was, pursuant to a scheme. And this honorable court, while on the first day, passed an order to obtain instruction as regards the reason for incorporating a clause like 2.2.2.4 and whether such clause is incorporated in view of the scheme for the special assistance to the states for capital investment, because, under this scheme, these construction works are being done for the year 2023-24. Now, subsequently, they have filed affidavit, and we have also filed an additional affidavit to show, that the scheme does not require such a, such a clause to be incorporated.
That is your submission.
Yes, ma'am.
Okay.
The APHC, the Assam Police Housing Corporation, also, recently issued other NITs, and PWD also, they have also now introduced this EPC mode. And the last NIT that has been issued by the Police Housing Corporation, that your lordship will find at page 42, there is no requirement of this EPC mode. Only registered contractors are allowed, that your lordship finds at page 42. And so far as the PWD is concerned, they have also, till September 2023, they have been going on this, the registered contractors as in the earlier. But then, one particular NIT will be relevant. That is, your lordship will get at page 47. That is an NIT of PWD. They have also introduced EPC mode, but contractors can engage firms and consultants. If, that is incorporated, had that been incorporated in this clause, additional qualification, then these persons could have been, they could have competed. In fact, my lord, if your lordship reads this particular clause again, minus this, my lord, leaving away this experience part, even now, my lord, we can engage the architectural firms because that is the only requirement. But having experience all on a sudden, not a single registered contractor will have that, my lord, that experience. If your lordship comes to my lord page 47,
Is this work confined to only registered contractors?
my lord, they do not say so now. Earlier, because my lord, Assam Public Distribution Order Act and my lord rules, that is the requirement, my lord, the contractor has to be registered first. Registration is, my lord, not a very big thing. That I'll say, but that requirement has also been, my lord, given above by. That will be, my lord, contrary to the rules of the my lord, procurement rules. Now, what the PWD has then done, that is, my lord, ideal situation at page 47, your lordship will find. And all these, my lord, works are not of very high value. Although, my lord, they have stated in the affidavit that it is of 100 crores. It is not, my lord, each and every contract, my lord, of a particular location.
I'm just interrupting. You have shown 27,
Yes,
which is the impugned NIT
Yes.
causing that offending clause, which
Yes.
you are challenging.
Yes.
Immediately on 15(9), this work does not have that requirement. Why?
It does have the requirement.
No, 15(9).
15(9), my lord, that is
Page
another
42.
contract.
That is, it does not require
Yes.
EPC.
It doesn't require. So all of a sudden, these works have been chosen, and that requires.
Is there a difference between these two? These are also, we have seen constructions of RCC building.
Yes, my lord. And the ideal situation is, my lord, we cannot really object to the EPC mode, my lord. That is a policy decision government will implement, but my lord, it cannot all on a sudden implement it and make all of us ineligible to participate.
Mr. Saikia, is it possible that they can involve some persons with experience of EPC as an architect?
This was discussed in the pre-bid meeting and it was rejected. Then there is a reason also. Because it is a time-bound project. If we do not start the work and utilize the money by 31st of March this year, whole fund will go back. That's a part of the scheme. So we have to be doubly sure that the bidder or the person who is selected to do this work, he has the capability of doing it as the earliest possible.
This particular work is under a scheme
Yes,
which requires EPC.
yes. Directly they have not said, but we have to ensure that the work is timely done by competent person.
No. If you can think over an option of having a registered contractor to have a tie-up with any architect, will it serve
But
your
this is
purpose?
regarding the past experience. People kindly see.
Yes.
This
No, see, they've been candid that they do not have the past
They
experience.
do not have. It
But-
is an incorrect statement because till now we have 16 bidders, 3 of them belonging to the registered ones. It is not that we are not getting that qualified
There are.
person. There are.
No, can you think of an option that if they
At
have
this
a,
stage, it is too late in the day, Lord. Otherwise, Lord, people see the scheme. 31st March 2024 is the last date. If
no,
we-
that will take care of. That for that only you are here having this.
But our stand is very clear, Lordship. Because we do not want delay and we want timely completion. And for that, as a employer, Lordship, we want to ensure that the work is timely completed by competent person. And there are ample number of bidders who are available.
And how do you justify page 42 then?
Page 42.
You are not insisting on EPC. These are also matters of.
All are not under
construction.
that central government scheme. This fund is not, maybe in all probability, it is not under that scheme.
No, you have said, you have clarified that the scheme does not make it very specific that there is a requirement of EPC.
There's another point. my
We
lord.
will come back, we'll come back. See,
The funds which you have received for this particular
with
scheme.
your objective to have the best
Yes,
thing done, that we do not have any issue at all.
exactly, Lord.
But to ensure that can't you allow a registered contractor to have a tie-up with a person having sufficient experience in
Here it is
PDPC
an
mode?
additional quality, it is a eligibility criteria. This is eligibility criteria because he must have this kind of work of 50% value during the course of last 7 years.
Now, my lord, that particular
Oh,
clause.
one
if I
second,
may-
one second. Is any partnership or joint venture allowed?
Yeah, so far as the earlier one, it was allowed. 2.2.4. 4 options are given, not only one option, which my learned senior friend is projecting. Lordship will
2.2
kindly
point?
come to page 36 once more.
Yes.
The contractor bidder should have experience of executing at least one building project. At least one. So a very minimum we are asking. Of value not less than 50% of estimated
Now,
cost.
who can bid? Who can submit their bids here? Have you specified?
Registered, not registered bidders, registered bidders under the government portal. Tender portal. Page 32. Clause 2. Page
Yes.
32. The contractor's bidders must be registered on the portal assamtenders.gov.in for participating in the bidding process for tenders floated by this department. It is the responsibility of the contractors to ensure that their portal registration is valid, not expired through the life cycle of the tender. So this is basically the first criteria. So they must be registered under the government's portal. Then eligibility criteria, page 34, 2.2. The bidder who fulfills the following requirements shall be eligible to apply. Joint ventures, consortium, special purpose are not accepted. Intending bidders must not be placed in the negative list of firms of any department or organization for any reasons, including failure, abandoning the project without permission of the department or organization, unethical practices, failure to abide by integrity pact, or failure to follow any lawful directions given by the department or organization. A bidder whose proprietor, partnership, director, or organization is having any FIR police case going on due to corrupt or unethical practices is barred from participating in a tender of Assam Police Housing Corporation Limited. Bidders must submit an affidavit in compliance of this clause. However, this clause is not applicable to central, state government, PSU organization. Next, qualification requirement of bidders, bid capacity. The bidders who meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the total bid value. That is clause 1.1.1. The available bid capacity will be calculated as per the following base. That is the formula. Then work experience is given. Experience of having successfully completed similar work during the last 7 years, ending the previous day of last date of submission, 3 similar works of 40%. Then or 2 similar work not costing less than 50% of the estimated, or 1 similar work costing not less than 80%. So these are the options, and this additional is at 2.2.24 next page. And 2.2.23 says construction of multi-storied RCC frame structure for building projects, including internal water supply, etc., etc. These are the requirements, similar work. Then additional qualification, here also he is getting 4 options. The contractor bidder should have experience of executing at least one building project of value not less than 50% of estimated cost during the last 7 years, ending last date of the month of previous to the one in which the tender are invited. These works should have been executed either on EPC mode, that is one option which is agreed by, or design and build mode, or the work was executed in-house architectural firm of the contractual bidder having structural engineer and architect. He must have his own. Or the work was executed by the bidder by tie-up with an architectural firm having structural engineer and architect. We have to submit the proof. So whatever has fallen from Lordship's mouth, that option is already given for the previous one particular work. If they have not done any work with this kind of arrangement, Lordship, these 4 options, then they should not participate, because we want this to be timely completed with quality work. And for that purpose, Lordship, I would like to place that central government scheme. In page 30 of our IA 3724.
Page
Page
30.
Lordship. Time complete. Each state will notify an agency of the state as the scheme for special assistance to state for capital investment, nodal agency for implementing this part of the scheme. The agency will open its saving account in a scheduled commercial bank and will onboard the same on public finance management system. The first installment of 50% of the approved amount will be released to the state or transferred to the bank account of the SASCI nodal agency for approval of the project. The second installment of remaining 50% will be released on or before 31st March 2024 based on progress made. In case the nodal agency is not able to complete the project within the stipulated time period, the amount available in bank account will be returned to the central government. Interest accrued on this amount will also be deposited in the Consolidated Fund of India through non-tax receipt portal within 10 days of its credit in the nodal account. So we have to run against time. All the work has to be done on war footing. And this tender also says the completion period is 18 months, page 32. When the tender was issued on 24/8/2023. Completion period 18 months.
Where page 32?
Page 32.
Which one?
Page 32 of the writ petition, Lord.
Oh, writ petition.
Lord, I'm sorry.
18 months.
18 months. And in the pre-bid meeting, this issue was raised. Page 53 of the writ petition. Clause 3. The contractor's bidder should have experience of executing so and so. This clause is stated. Views given by the bidders present in the pre-bid meeting.
Where are you reading?
Page 53 of the writ petition. 5944.
53, yes.
Page 53, serial number 3. First, Lordship will kindly see the elaboration of the clause. Then in the middle part of clause 3, serial number 3, views given by the bidders present in the pre-bid meeting. Maximum number of bidders present in the meeting raised a question to reconsider the above clause. They stated that EPC contract is very new concept, and as such, maximum of them have not executed any work in EPC mode or having their in-house architectural firm or tying up with any architectural firm. But they are all well experienced in construction of similar building work. Resolution: the member of the authorities present in the pre-bid meeting decided to keep the clause unchanged. So the reason being, if reason is not in place, we want timely completion and quality work. That is the reason, Lordship. So it was discussed, and therefore, Lordship, it is very difficult on my part to give any concession because the expert body and the employer has applied their mind and finally come to the conclusion that we do not want to change it. And on top of that, Lordship, there is a wide participation. 16 bidders in this category is a huge number. And 3 of them are from the association also, registered contractors. So if 3 members of the association fulfill this criteria, Lordship, that means the other could have also done it. And it is not that only one option we have given. We have given 4 options. That means they have done their earlier work without architectural firms assistant, engineering firms assistant. They must have done it in a very clandestine way. So here, as the money is coming from central government, and there will be wide scale monitoring. And we do not want to have a bad name. Lordship, Lordship may have a look of this police reserve. New buildings are coming up. All these constructions are for urban housing. This is a part of the urban housing. The Home Minister laid the foundation stone about a year back of this project. Series of projects are going on. We want to revamp and urbanize the police force. For a few contractors, these works are now pending. There's a stay order operating. Therefore, we filed a vacating petition also. And the Lordship is taking up this matter on out of turn, Lordship, because there is urgency. Otherwise, Lordship was not pleased to take up the matter today. I made a submission on the last occasion showing our urgency. So we are at the fag end of Lordship, the financial year. If we do not start the work right now, Lordship, there is every possibility the state will suffer, the public interest will suffer. So basically, this is our case. We have stated our reply in our affidavit. Paragraph 6, a long paragraph. Lordship, I would like to read out this paragraph.
Page?
Page number to 9. Page, Lordship, 455. 455. That with regard to the statements made in paragraph 5 of the petition, the answering deponent begs to state that the inclusion of the additional qualification in clause 2.2.24
You're reading paragraph 6?
Paragraph 6, page 5, 455.
Yes.
With regard to the statements made in paragraph 5 of the writ petition, the answering deponent begs to state that the inclusion of the additional clause in clause 2.2.2.4 of the NIT dated 24th August 2023, it is submitted that the aforesaid work are to be executed under the scheme of special assistance to state by for capital investment 23-24 of the Ministry of Finance, Government of India. The said scheme envisages housing for police personnel above or as a part of police station in urban areas. The purpose and object of the scheme are to increase the housing facilities for the police personnel and their families in the urban areas, which would involve construction of RCC, LS quarter at different locations, etc. As per condition of the aforesaid scheme, the first installment of 50% of the approved amount would be released to the state for transfer on approval of the project to the bank, and the second installment of the remaining 50% will be released on or before 31st of March 2024 based on the progress made. The mandate of the scheme is to the effect that in case the nodal agency is not able to complete the project within the stipulated time period, the amount available in the bank would be returned to the central government. Interest accrued on this account would be deposited in the so and so. Next, since the aforesaid scheme is a time-bound project, it would require the nodal agency to ensure completion of the project within the stipulated time frame, and to complete the project within the time period, it would require bidders with adequate financial capacity with sufficient experience of design and construction together, capable of completing the EPC project on time, within time. So this is the reason, Lordship, we have disclosed in the affidavit. The respondent corporation further begs to state that it is not for the first occasion that the answering respondent has initiated bidding process on engineering, procurement, and construction mode of contract. Earlier, this would be several times. It is not second, it is a typographical mistake. Earlier, several times the authority has initiated bidding process on engineering, procurement, construction mode. So this was not new, Lordship. For the first time, we have introduced this. The allegation of bias as sought to be projected by the petitioner in the conclusion paragraph 5 is categorically denied by the answering respondent. It is submitted that the present bidding process initiated by respondent number 3 through EPC mode does not restrict it to few bidders. Rather, the bidding process is thought to be made more inclusive and competitive, requiring bidders with adequate financial capacity and expertise capable of completing the EPC project within time. Next is paragraph 7, little bit Lordship here. The answering deponent begs to state that the instance of the recent NIT dated 15/9/2023 floated by respondent number 3 of following rules laid down by the Assam Public Procurement Rules 2020, which is of similar nature as the present NIT dated 24/8/2023. It is completely misleading as both the NITs are different, as the NIT dated 15/9 was not advertised through EPC mode, and the contract value of the said tender was 45,82,494, whereas the total contract value of the present contract would be excess of 1,100 crores. So that is 45 lakhs only, which would require incorporation of certain additional qualifications of the bidders to ensure completion of the project within the time period as stipulated in the scheme. So in several districts, the bidder will have to start the construction and do it on time.
This present work which we are concerned
It is 100
is
crores.
more than 100 crores.
100 crores. I submit that.
And the 15.9 is of 45 lakhs.
45 lakhs.
Not
On
even-
affidavit, we have said, Lord. And regarding the registration, Lord, whether we can open the tender for registered contractors of the housing board, or they can be general, Lordship. The law is very clear on this, Lordship. In this regard, the writ petitioner is relying upon that Assam procurement Assam Public Procurement Act 2017. This is their ground. This is the second ground they have taken. Here, registration of bidder is covered by section 19. And in section 19, there's a specific clause. 19 subclause 6, subsection 6
Of
Assam Public Procurement Act 2017. Their ground is that all the bidders should be registered with the Assam Housing Board, Police Housing Corporation. Of course, out of 13, 3 are registered who have participated. So we have 16 bidders in place. 19 rule, section 19, subsection 6 says, new bidders and contractors shall be considered for registration at any time, if they fulfill the required criteria and conditions and apply for such registration. The procuring entity shall upload the details of the criteria, conditions, time frames, and procedures of registration of new bidders, firm and contractors in the state public procurement portal and the department website. So what we have asked for in the tender notice is that they should be registered under the Government of Assam portal of tender. Now, if we have to accede to the, or if we have to respond to the ground which they have urged in their second ground. that-
Your requirement is that registration with has to be the government of state government.
Yes, Lordship, with the tender notice, Lordship, may kindly see first clause itself. Page NIT,
27,
page 32,
32.
notice inviting bids for e-tendering, clause number 2 of the tender dated 24th August 2023. The contractors bidders must be registered on the portal www.assamtenders.gov.in for participating in the bidding process. So all must be registered. We are not segregating in that they should be registered with the Assam Police Housing Corporation. This is the government agency, instrumentality of the state government, which comes under Article 12 of the Constitution of India. So we want to expand the competition, we want better person, and we want timely completion with quality work. And if we are doing that, Lordship, although it is a commercial activity after all, if the building is not coming out rightly, all the TV portals in the evening, Lordship, will see in the TV news. The walls are cracking, the fans are not working, all these things. So we want to ensure this. Lordship, no, Jorhat Medical College, we constructed it without all these conditions. After the building was open, how many news items came out from Jorhat Medical College? We are also learning, the government is learning, Lordship, that we have to abide by the criteria of quality work. Although these are welfare schemes, but at the cost of quality, or we cannot dilute the criteria of a tender. And it is not that it cannot be fulfilled. 4 options were given to them. One is EPC. What about the other conditions? Other conditions are very simple. that they should have done 50% value work in one work during the course of last 7 years with tie-up with an engineering or architectural firm. That is the minimum requirement, Lordship. Otherwise, the person with whom we give, we call the contractor or the thickener, he will do the work, not engineers will come. All the mismanagement will take place. So this is my humble submission. We are already late in the day, Lordship. We hardly have 2 months left now till the financial year is over. So my humble submission is that they may lose certain things, maybe financially, but Lordship would allow us to go ahead with the tender process. If they can, if the Lordship is pleased to take up the matter for final disposal, this will be my same submission I will make, even whether it is for the vacating petition or for the main disposal case, Lordship. But my humble submission at this stage is that Lordship may be pleased to vacate the order, and if Lordship is taking up for final disposal of the case, then Lordship may be pleased to dismiss the writ petition. This is my humble submission at this.
I did not complete my submission, my lord. If I may respond.
Just a minute. What is the interim order passed?
Not to
work
issue.
order shall be.
Where?
We are allowed to proceed with the tender process.
That is the order dated 6th of November 2023.
No final order shall be issued to the successful bidder, page 24 of the vacating petition, 2734. Till next date fixed, this order was issued 6/11/2023. But earlier interim order was rejected also. There is a detailed order, Lordship. There are 2 orders.
Yeah, we went on appeal. The appeal sent it back before the honorable
7,
judge,
9,
and thereafter interim order was passed.
page 13. My Lord Justice M. Chaudhary's court ordered 9/10/2023 refused to grant any stay order. A detailed order was passed, Lordship. At paragraph 20, very clearly the opinion of the court was the impugn clause prima facie does not go to indicate that because of the said clause, the bidding process has been restricted to a few bidders. Having regard to the fact that the notice inviting RFP, the tendering notice seeking to execute work relating to so and so in 16 districts with the fund of central government under the special assistance to state for capital investment, which are projects for providing infrastructure police department. So 2.2.2 was discussed, and prima facie that is the opinion of one of the honorable court. And therefore, no stay was granted. But subsequently, on 6/11/2023, till the next date fixed, page 24, no final order shall be issued to the bidder. That is why our whole process is complete. We have to just issue the work order now. Okay.
Yes.
Now, my lord, I'd like try to meet my lord all the points raised by my learned friend and Professor General. Firstly, my lord, it has been stated that the matter is urgent. And 31st is the last date. Now, your worship will notice that the scheme came into being in February. In February 2023, the scheme was launched. That your worship will find, my lord, in the scheme has been, my lord, there on the record. We have given a copy. Guidelines on the scheme for special assistance to state for capital investment 2023-24. This is dated 3rd of February 2023. And my lord, NIT was issued on 24/8/2023. February, March, April, May, June, July, August. This waited for 7 months, more than 7 months, my lord, 7 months and 20 days to issue the, my lord, NIT. Then, my lord, they had on their own extended the last date. Now, creating an emergency, they cannot take benefit of that, saying that this is a time-bound project. What have you been doing for 7 years and 7 months and 20 days? Sleeping over it. And now you say this is very urgent. This is my lord, one submission. Secondly, my lord, it has been tried to project that the work value is of 100 crores. That is absolutely wrong, my lord. Your lordship will kindly see the NIT. Each and every work is about 7 crores. And one tenderer will be allowed only, my lord, 4 contracts maximum. That comes to, my lord, 28 crores. Total value of the, my lord, entire project may be 100 crores.
That is what has been stated.
Yes, but that is not relevant because, my lord, one contractor can be given only 4 works and each and every work is only 7.7 crores and odd. Therefore, my lord, because of that, my lord, these persons are, it's very high value, therefore big players are required. That is not correct. And so far as the performance of the existing contractors are concerned, my lord, there has not been any complaint till now. They could have blacklisted anyone. And they will participate, my lord, in small 7 crore works. They will participate in that. And they fulfill all the requirement. If your lordship kindly see, accept that experience part. Because the 4 options my learned friend was, my lord, harping on at page, my lord, 35 of the writ petition. If your lordship kindly comes to 35 of the writ petition. And I'll also show, my lord, this particular clause is contrary to their another clause in the NIT. I'll show that, my lord. Before that, your lordship will kindly come to page 35 of the writ petition.
Yes.
Clause 2.2.2.2, work experience. Experience of having successfully completed similar works during the last 7 years ending previous to the of the last of the submission of tender. The 3 similar works, each consisting not less than 40% of the estimated cost of the project, that is 2 crore 80 lakhs and odd, or 2 similar works, each consisting of not less than 50% of 3 crores and odd, or similar work consisting of not less than 80% of the estimated cost of the work. This, my lord, these existing contractors, my lord, members of the petitioner, they, my lord, fulfilled. Then only completed substantial completion, completing works for which a certificate of successful completion so and so, this they require, this they fulfill. Then 2.2.2.3, similar work shall mean, that has been explained. And these, my lord, all they fulfill. The problem is with the, my lord, clause 2.2.2.4, where the experience in EPC or design and build is, my lord, required. Because, my lord, 4 options, my lord, in fact, the Honorable Justice M. Chaudhary also discussed this and misunderstood this. And that is why we went on appeal, and the appellate court has remanded it back for consideration of the interim prayer, and interim prayer was granted. May I read, my lord? Your lordship will kindly give me permission to read this clause again.
Please, please.
The contractor bidder should have experience of executing at least one building project of value of not less than 50% of estimated cost during the last 7 years. This will fulfill ending last date of the month previous to the one in which the tenders are invited. We fulfill. These works should have been executed either in EPC mode or design and build mode. This is where the objection is. Or the work was executed with in-house architectural firm of the contractor bidder having structural engineer and architect, or the work was executed by the bidder contractor or tie up with an architectural firm having structural engineer and architect. Now, these requirements are not there earlier, therefore we do not have any architect in our architect in our firm, or we do not have any tie-up and we do not have that experience, EPC mode. So this disqualifies us. Then your lordship will kindly take up my additional affidavit. I have, my lord, enclosed the entire document where I'll show that this 2.2.2.4 is contrary to this particular clause, architectural service. My additional affidavit filed on 6th of November 2023, page 312. That big volume. Has your lordship got it? Clause 2.2. Architect
312.
312. 2.2 architectural services. Two point 2.1 has your lordship got it?
Just a minute. 312. 2.2.1.1.
Yes, my lord. 2.2.1.1. The bidder should engage.
This is
in a-
what, these are what?
This is volumes of the NIT, my lord. Because
Okay.
the entire NIT was not.
Part of the present NIT.
Yes, my lord. The bidder should engage a reputed firm, architect, architectural or engineering firm who is conversant with the local bylaws, NBC and other rules regarding architectural services for preparation of the drawings for the project in a time-bound manner. The architect shall be required to submit and present the concept plan, methodology, and work program during the tender stage. The authority is not bound to accept the concept plan as is and may suggest some or many modifications in the conceptual plan and methodology. This will be binding on the successful bidder. All costs, fee regarding preparation and modification thereof to the conceptual plan, model, walkthrough, traveling and lodging cost, honorarium, etc., to be paid to the architect shall be borne by the contractor. The authority will have the intellectual right on the conceptual plan, model, etc., and will have the right to use some of the concepts or features from the drawing submitted. Now, my lord, if this is allowed, minus the experience part, because this will, my lord, fulfill the requirement, then, my lord, we are eligible. This is contrary to the, my lord, clause 2.2.4. The usual practice earlier was that, my lord, designs are being done by them. Now it has been given to the, my lord, under the EPC mode, we have to do it. Now we can have a tie-up under this clause. Then submit in and thereafter they'll approve it. Approval, your lordship will find page 239. So this is self-contradictory. 239, your lordship will find
Two hundred?
239. And my lord, I do not understand, my lord, what is the effect of the quality of construction on the design, because that is based on the procurement and the, my lord, the completion of the construction. Design part does not, my lord, reflect the, my lord, quality. because my learned friends were saying about some qualities. That is because, maybe because of the construction on the, or the material, my lord, procurement of the material and the construction. It cannot be because of the design. Now, this page 239, your lordship will kindly.
If the design is faulty, will it be
That
appropriate?
has to be approved by them. That is what I am trying to point out, my lord. Plus 1 point, no, otherwise, my lord, earlier what they did, they had the design.
They had given the design.
So design is theirs, my lord. If that is faulty, the contractor could not have been, my lord, made liable for that if that is faulty. Now they are trying to do this, and if your lordship kindly comes to clause 1.1.2. Before that, in the chart, your lordship will find, my lord, there are this works, my lord, estimated project cost is 7 crores. One particular contract, it is only 7 crores, not, my lord, 100 crores that my learned friend was, my lord, harping on. And at base, my lord, they can give it to 4, so that will come to 28 crores. And my lord, all the members of the petitioner association, they fulfill this. Now, this clause 1.1.2, the selected bidder, the contractor, shall be responsible for preparing the detailed site master plan, architectural and detailed design, engineering, procurement and construction of the project under and in accordance with the provisions of an engineering, procurement and construction contract, the EPC contract, to be entered in between the contractor and the authority in the form provided by the authority as part of the bidding document pursuant hereto. The structural designs, drawings and design calculations prepared by the contractor shall be vetted by the Assam PWD, government engineering colleges, IIT, NITs at the cost of the contractor from safety and quality perspective. The contractor shall also be responsible for the maintenance of the project during the defect liability period at his cost, etc. Now, my lord, this requires that the design has to be approved by the appropriate authority. Now, that will come, my lord, only after one particular bidder is selected or so many bidders are selected.
It shall be vetted by the.
Yes. So this is not that, my lord, today they issue the order and on turnkey basis, my lord, they start it. There are further procedures to be done. And that is why I was, my lord, harping on this point. What did you do from February, 3rd of February to, my lord, the August? 7 months and 20 days. Thereafter, you issued the NIT. And you yourself extend the time last day. And now you say that this is urgent. And in any case, my lord, even if the work order is issued today, they cannot complete it. Period of completion is 18 months. They cannot complete it within 3 months. If they complete it in 3 months, my lord, it will fall down.
No, the submission made is just the fund is going to go back if the work is not started in 31st of.
Yes, my lord. Even if, my lord, your lordship allows us to participate, minus this, my lord, experience, relying on that particular clause, my lord, they can, it's not that, my lord, we will get it. We can compete at least. And thereafter also, my lord, 31st month is quite.
But how do you overcome which the settled law that the employer has the discretion to insert clauses, and unless those clauses appears to be grossly unreasonable or against the public interest, then at the instance of certain person, interference may not be possible.
My lord, I understand your lordship.
And the immediate question will be that was under a particular scheme. And on 15/9, you have another contract, a notice where the members of association like you can compete. And he has also, Mr. Saike has also given the instance of 3 of your members who had participated in this bidding process along with 16 others.
On that, my lord, I don't have instruction, but then, my lord, I'd like to. Is
the condition so, what do you call, oppressive that it will reduce a fair competition and it will be against the interest of public service?
My lord.
And more so when it's a contractual matter where powers of judicial review, as you know, is very circumscribed.
True.
Only 3 conditions which have been settled by Michigan River, then Central Coal, then this Mandal's case, Jagadish Mandal.
Yes.
There has to be some malafide involved. It has to be grossly unreasonable. or public interest has to be adversely affected.
I'll, my lord, submit on the unreasonableness. Firstly, my lord, all the existing contractors, they are ousted by making it open to some new competitors. And my lord, while doing so, they have they provided for registration in the portal, giving a go by to the my lord Assam procurement rules. And they act.
No, this is under a central scheme.
This is under a central scheme, and the scheme does not say, my lord, let him show, my lord, from the scheme itself that EPC mode has to be done. That is not there. That was the instruction that was called for on the first instance, my lord. That instruction, the papers, my lord, they have given. That is not there, my lord. EPC mode, fine, my lord. I understand. EPC mode you are doing for the good general, but how do you, my lord, take away our livelihood all of a sudden by introducing it? And when, my lord, this particular clause is there, that you can.
No, there'd be a very easy answer for you, because this is not the only work which you would be interested in. There'd be hundreds of other works.
Yes.
The question of affecting your livelihood for forever, that will not come.
No, my lord, it will be, it will go away forever, my lord, if we do not participate in this type of tenders. If we are excluded now, how do we gain the experience? We do not gain the experience.
But with the
After
change,
working for-
with the change in trend, the requirement of
No, that's
new
why, my lord,
qualifications.
that's why, my lord, even PWD, while issuing, my lord, the EPC mode, they have given some scope so that, my lord, they can also participate. Even, my lord, this particular clause also, my lord, says that you can have a tie-up. That I was drawing attention to your lordship on page 312. This is very clear, my lord. And clause 2.2.4 is in contradiction to this, contradicts this particular provision. We could have engaged the architectural firm. You are asking us without giving us this opportunity also, which is a part of your tender paper.
Just a minute.
Only then, my lord, these large number of contractors, my lord, local boys, my lord, they'll get their opportunity henceforth, my lord, for participating in EPC mode.
Should engage a reputed firm who is conversant with local bylaws and compliance for projecting time. With experience of executing at least one building project. Either on the kissing mode or design and build. And whatever in our architecture. See, so far as we're just testing your argument.
My lord.
You have said that clause 2.2.1 at page 312
Yes,
is contradictory with the additional requirement.
yes, my lord.
Let us read side by side.
My
The additional qualification, which is the offending clause as per you, says that the contractor bidder should have experience.
Yes.
This is only with regard to experience, okay? Of executing at least one building project of value not less than 50% of the estimated cost
Yes.
during the last 7 years, ending so and so, previous to one. Now, you have to have a building, at least one building whose value is not less than 50% of the
Yes.
project.
That
Now,
we
what
have-
is that building? This works should have been executed either on EPC mode or EPC is only one.
Yes.
It's all or. Then design and build DNB mode or. The work was executed with in-house architectural firm of the contractor oblique bidder having structural engineer and an architect, or the work was executed by the bidder contractor by tie-up with an architectural firm having structural engineer and architect.
Yes.
This clause is only concerning your experience of a similar house of less than of more than at least 50% of the
50%,
estimated
yes,
cost.
yeah.
And while having that experience is qualified
By
by
the-
4 conditions,
Yes.
either any of
Either
the
of
4
them, yes.
conditions. Now, this clause which you are now trying to project
Yes.
to be contradictory as 312, at page 312, kindly
Yes.
come to that clause.
The bidder should engage a reputed firm.
This is while you execute the work.
No, my lord, this has to be prior to execution of the work.
Exactly. This is for the work in question. This has got nothing to do with the experience.
No, my lord, this will be, that particular design will be done, my lord. This has to be prior to the filing of the tender paper, filing of the bid.
This requirement of 2.2.1.1 is with regard to the work which would be given to you provided you are a successful bidder. This has got nothing to do with your experience.
That's what, my lord, I say that we do not require that. You can, if you invoke this, then the.
No, if they're insisting on an experience on giving you 4 options, can you term this to be an arbitrary or
My lord, the
unreasonable?
4 options, my lord, each and every one, my lord, disqualifies the existing contractors. That is what I am on, my lord. Because they cannot have, maybe, my lord, 3 persons, my learned friend has said that 3 contractors.
See,
have
all
participated.
extents, all
No,
extents.
that, my lord, that your lordship will kindly read with their affidavit. There have been shortfall of documents. Then after shortfall of documents, my lord, they have given this, they have considered the shortfall documents. Then, my lord, perhaps 3 persons have qualified. That I am not very sure of, but the affidavit, the minutes will show, my lord, there have been shortfall of documents. There have been, then it has been considered again. Page 48 is the, my lord, minutes of the technical bill.
See, it is not your case that there being a clause requiring a certain experience, bidders or persons have been selected or shortlisted without fulfilling this experience and you have been left out. You are challenging the validity of such experience.
Yes.
Now, whether a person who is undertaking a work would be debarred or would be questioned if he insists upon experience, will that be proper? And when that requirement of experience appears to be fair and reasonable,
My submission will be, my lord.
only
this-
because one part is excluded.
My lord, my submission will be, my lord. The scheme did not say that you have to go in this mode. They have.
Substantiate this.
Yes, my lord. If
the
you are
scheme- the
come
scheme
to the
part.
scheme, my lord,
Scheme part.
because that was the query done, my lord, by the honorable single judge
Let us see
initially.
let us
And
see the-
pursuant to that, my lord, this has been placed before the record. Instruction produced by the government advocate on 9/10/2023.
Is it a part of the records?
Yes, my lord. That was produced before the court. And subsequently, my lord, we have obtained a certified copy of that.
What is this? Tell us.
My lord, at the top, your lordship will find, this is WPC number, the order.
Now we have some records. Is it a communication? 710?
Yes, my lord.
710?
17.
Yes. Which part?
17, my lord, the reasons they have, in paragraph 2, the reasons they have given. My lord, your lordship has seen the minutes. This was raised in the pre-bid meeting and it was rejected without giving any reason. But now, my lord, in this communication, they have thought to give some reasons, my lord. Paragraph 2, if your lordship kindly read.
Yes, please.
As regards the reason for inclusion of clause 2.2.4 in the NIT dated 24/8/2023, it may be stated that the aforesaid scheme is a time-bound project in terms of point number 5 of the guidelines of the scheme for special assistance to the state capital investment, dated 3/2/2023, issued by the Minister of Finance, Government of India. As per the said guideline, the first installment of 50% of the approved amount will be released to the state for transfer to the bank account of the SASTI nodal agency on approval of the project. Then, my lord, this is the urgency part they are showing. Then, my lord, next paragraph. There, my lord, I have already, my lord, brought your lordship notice. This is 3/2/2023 scheme introduced. NIT issued on 24/8. Then last date was extended, my lord. It was 29/9. It was extended to 9/10. Then, my lord, administrative approval was granted only on 6th of October. Now, in this context, it may be further stated that in some earlier EPC tender floated online by the Assam Police Housing Corporation Limited, as well as few other government departments, had also laid down a similar criteria, which has been followed in the present NIT pertaining to clause number 2.2.4. So this is the reason given. Then, my lord, scheme your lordship will find, my lord, after 2-3 pages, scheme is 3rd February 2023. Issued by the Government of India, Ministry of Finance. Dated 3rd February 2020.
Yes.
Guidelines on the scheme for special assistance to states for capital investment. These are the guidelines, my lord. In these guidelines, my lord, subject to correction, I do not find anything which shows that, my lord, it has to be, my lord, on EPC mode. My lord, the part 5 of this is, my lord, regarding the police house personnel. After, my lord, 2 pages, up to 3 pages, my lord. Roman 5. Part 5, housing for police personnel above or as part of the police station in urban area. This part of the scheme aims at increasing the housing facility for the police personnel and their families in urban areas. It further aims to save the time and energy of the police personnel wasted in commuting to reach the place of their duty. It will also help the quick response in case of any law and order problem or disaster. An amount of rupees 2,000 crore is earmarked for the part of the scheme. This amount will be available to the state for building so and so. These are the conditions. Each state will notify an agency as a scheme for special assistance, nodal agency for implementing this part of the scheme. This scheme will open a savings account so and so, my lord. Nothing has been stated that it has to be on EPC mode. That was the first query made by the court, but they could not produce anything. Now, my lord, I'll also like to draw your lordship. This may not be relevant, my lord. There is a communication for administrative approval. Now, if your lordship kindly comes to that administrative approval dated 6/10/2023. There are 2 examples, my lord, where this scheme specifically states about, my lord, EPC mode or silent about EPC mode. Has your lordship got this communication dated 6/10/2023, my lord? A little later in this month.
Just a minute.
Yeah. 6/10/2023, my lord.
But it appears that this particular kind of an experience clause was also there earlier.
That is what, my lord, I am trying to show. Here, my lord, while giving administrative approval, this document was given, my lord. If your lordship comes to that 6/10/2023
Yes.
communications, administrative approval of the competent authorities hereby accorded for an amount of rupees 135 crores. Then your lordship will kindly come to next page. This is for the battalions, my lord, 156 crores.
Yes.
This handwriting is, my lord, theirs while producing inspection, my lord, 156 crores, my lord.
Yes.
There, the additional qualification is, my lord, specifically stated, the contractor bidder should have experience of executing at least one building project of value of not less 50% estimated cost of engineering, that is under EPC mode.
Or designer building.
Yes, designer. That, my lord, the requirement which has been incorporated in clause 2.2.4, this is there in case of, my lord, battalion, because that the value is, my lord, 156 crores. I am trying to distinguish. I will show another example, my lord. When it is
But
very,
battalion is also not one complex. These are also different complexes.
it's not a housing complex, no, it's a battalion building, headquarter building, one building, one work.
It's ultimately it's a construction.
It's one work, my lord.
It's a
What I am-
building construction.
Yes, my lord. What I am on is that now in the present, my lord, contract under challenge, NIT under challenge, you have got
Where is that contract, battalion contract? This particular clause which you were reading as part of the battalion, the third annexure rather.
Yes.
Is it in context with which work?
This is regarding battalion. These are the documents they have produced.
No, understood. Where is the work?
That has not been given by them. But it says, my lord, EPC mode is there. There is another example, my lord. World Class Academy, my lord. There also, my lord, the police academy building there, my lord, EPC mode is there. So far as the, my lord, present contract is concerned, that has not been, my lord, envisaged under this scheme. That is my lord submission. In fact, my lord, in the other example, my lord, clause 2.2.2.6, eligible experience of the eligible project in respect of each category. It should have been under the EPC mode or procurement and contract construction mode or other similar basis for providing its output of service to a public sector entity or for providing non-discriminatory access. So, my lord, here they have provided both either EPC or the procurement and construction. All these, my lord, decades we have been doing, my lord, procurement and construction. And we do not, in a small contract like this, 7 crores, my lord, we do not get the, my lord, opportunity to enter and compete so that we have the experience. So, my lord, the sum and substance is that, my lord, this scheme did not envisage. In others, my lord, in other projects, they had envisaged either EPC or either APC or procurement construction. But here, my lord, there was no requirement that it has to be EPC. And therefore, my lord, incorporating that clause, and that is also, my lord, contrary to 2.2.1.1, my lord, this is unreasonable. I am on unreasonable because, my lord, they are giving red carpet to some big players. And, my lord, the small contractors like the members of the petitioner association, my lord, they'll be out of competition, out of job.
You are required to perform only 50 work of at least 50%.
The mode, my lord, the EPC mode, there lies the difficulty.
How can it be a big contractor?
My lord?
How can it be a big contractor? Maybe a smaller contractor.
We are small contractors.
No, even smaller than you.
No, my lord.
At least 50%.
50%, but, my lord, we have to have a design. This we did not.
Smaller but modern contractor.
My lord, this requirement was not there. Therefore, we do not have any tie-up with my lord, any architect on our roll. Now we'll have, certainly. But can you ask us in this manner? By introducing this particular clause, which is not a requirement in the scheme. The question is, my lord, whether this is arbitrary or not. Inviting, my lord, big players only. As if, my lord, these contractors have been all these 30, 40 years, they have all of their work are bad. Have they, my lord, blacklisted anyone? They have not taken this ground. That these small contractors, they cannot perform their work properly. All we want is that we should be allowed to participate. And there has been some relaxation regarding this experience. So that, my lord, we can participate and we can tie up, my lord. We'll now tie up with the architectural firm, or maybe we'll take the architect in on our employment rule. Can you arbitrarily impose this, which is not envisaged under the scheme? That is the, my lord, primary issue that I am raising before you. And this was agitated in the pre-bid meeting. You do not give any reason why this has been included. We have raised this. This has been, your lordship has seen that minus. This has been rejected. Why rejected? Give the reason. Why we are bad? Are we bad players?
You're not bad.
But there are better persons because they have more finance and they are, my lord, big
They have
players.
not termed you to be bad.
Ousting us, my lord, ousting us from the competition. Is it a level playing field? Limited. And my lord, this can be a, my lord, conditional subsequent.
Then somebody else will come. I am not experienced.
That your lordship will deal at a proper time. My lord.
The
But
buck,
we are out of livelihood.
the buck has to stop somewhere.
No, buck has not started yet, my lord. It has just been initiated. Your lordship has to stop it now, my lord, for the time being. So that, my lord, they can run their livelihood, my lord. And let them get this EPC experience now on.
Okay, since we have heard substantially, we'll dispose both the IA and the
Main case, my lord.
writ petition.
Yes, my lord.
Any decision you like to?
My lord, all those decisions which are arbitrariness, I don't want to burden your lordship, my lord. I am only, my
Please
lord,
burden.
my lord, I only say that this is arbitrary. This was not envisaged under this scheme, and they have introduced it, and they have also provided in clause for 2.2.1, where, my
That
lord,
you
they
have
can
said.
make this relaxation.
Mr. Saiki, any
Yes,
case?
lordship, I have several judgments have filed up. One is Balaji Ventures, 2022 online SCC, page 67, paragraph, I'll give this copy, paragraph 9 to 12. Then Michigan Rubber, 2012 8 SCC, page 216, paragraph 35. As noted in various decisions, the government and their undertakings must have a free hand in setting the terms of the condition tender, and only if it is arbitrary, discriminatory, malafide, or actuated by bias, the court would interfere. Lordship has already said
I will
that.
rely on that decision.
Then Uflex
That is
Limited versus Government of Tamil Nadu, 2022 1 STC, page 165. In fact, every tender, there are certain qualifying parameters, whether it is with technology or turnover. The court cannot sit over in judgment on what should be the turnover required for an equity to participate. I am giving everything, lordship. Then Monte Carlo Limited. It has also been observed that by way of judicial review, the court cannot examine the details of the terms of the contract which have been entered into by the public bodies. Court have inherent limitation on the scope of any such inquiry. Then Tata Cellular is there. Jagdish Mandal. Contract is a commercial transaction. Evaluating tenders and awarding are essentially commercial functions. Principles of equity and necessity stay at a distance. Then Ronak International 1999 1 SCC, page 492. All the paragraphs we have stated. I have highlighted, they also seriously affect the industrial development and resulting job opportunities for a large number of people. In the present case, there is no overwhelming public interest in stopping the project. There is no allegation whatsoever in any malafide or collateral reasons for granting the contract to Ronak International. So these are the judgment I am submitting. And regarding his additional argument, which is not pleaded, lordship, that it is not part of the scheme. If lordship is pleased to take up my affidavit in opposition.
Yes, yes.
Page 460.
460.
460. Supplementary guidelines for part 2, 4, 5, 6, and 7 of the scheme of 2023 and amendment of guidelines of the scheme of special assistance to state for
Just a minute,
capital investment.
Just a minute. 460.
460.
This is supplementary guidelines.
Yes.
2nd May.
2nd May, lordship.
What is there?
There, Lordship will kindly come to page 463, part 5. Housing of police personnel above or as part of police station in urban areas. Objective is there. Have Lordship got it, 460. Then scope, financial assistance, etc., financial allocation, flow of financial assistance, and Roman 8 at the 464. There should be a nodal agency, and in case the nodal agency is not able to complete the project within the stipulated period, the amount available in the bank shall be returned to the central government as per the directive. So we have to engage a nodal agency. Here, the nitty-gritties and modalities.
Where
of
are you reading? Page 464.
464, Roman 5 from top, Roman 8.
In case of nodal agency.
Yes.
Is not able to complete.
Yes. And Roman 1, previous page, 3.4.
Single notified.
The state government will notify a single nodal agency for implementing this part of the scheme. It will be called as SAS, CI, SNA for the purpose of these guidelines. So we have to engage the nodal agency and we have to give the work for execution. So what will be the modalities, what will be the earnest money, etc. All the nitty-gritties of a tender process are not part of the scheme. The scheme has not laid down any eligibility criteria who can participate in the bidding process. What my learned friend is now trying to develop his argument that it is contra to the scheme. The scheme has not laid down any such condition at all. This is not there. There are cases on twofold. That 4.2.2.2, that particular clause is arbitrary. And number 2, non-registered bidders are allowed to participate. These are the two grounds on which the writ petition has the foundation. And they went to the division bench, not for anything else. They wanted some documents to be submitted that I have placed. Writ appeal. Very short order, 19/10/2023. Sri so-and-so learned senior counsel assisted by so-and-so submitted the writ petition before the learned single judge was filed in extremely urgent emergent situation. Complete documents could not be annexed therewith, and as a result, the appellants were prevented from projecting their entire case before the learned single judge at the stage of claiming interim relief. So the learned single judge gave her opinion that prima facie there is no arbitrariness or any fault in the clause. Sri Chaudhary further craved liberty of the court to file relevant documents in the writ petition and to make a prayer to the vacation bench for considering the prayer for interim relief at an early date. In view of the submission, the appellants were given liberty to approach the learned vacation judge with a prayer for emergent hearing for consideration of interim relief and with the additional documents which may be filed in the intervening period. With the above observation and liberty, the proceedings of these writ appeals are closed. So writ appeal was on a very limited scope or ground. Thereafter, the second order was passed where that we should not issue the final order. That order came by my Lord Justice Chiam. Now, a lot of argument has been made that why there is a delay of 7 months, 20 days or something like that. The administrative approval we received on 6th of October. The last date of tender was issued, I think, on 24th of August. Last date of submission was 29th of September. We granted an additional extension up to 9th of October. In the meantime, on 6th of October, we received the approval. So without approval, we cannot issue any tender. It will directly violative of Section 7(1)(g) of the Assam, this 2005 Act.
FRBM Act.
FRBM Act. It will become a criminal action. The officers will be under prosecution, criminal prosecution. So we know that. Therefore, once the approval was received on 6th of October.
Why are you smiling?
Tender was minor earlier.
Tender
and
was
approval was more subsequent.
Tender was earlier because we are of the view that it is going to happen. But still, last date was extended. We have extended. We have not issued the work order. The problem is with the work order. We cannot allot a work. The Act prevents from issuing a work because a lot of PWD cases earlier, Lordship knows that work was given, executed, but no payment of the contractor's bill. And finally, when this honorable court exercises jurisdiction, then it comes to the knowledge that there was no approval, administrative approval regarding the allotment of fund. So to prevent that, Lordship, the FRBM Act of 2005 was brought into place. There is another reason for the education department excess employment. So it was extended till 9th of October. In the meantime, by 6th of October, the approval was obtained. So there was no lacuna or default on the part of the corporation officers in issuing the tender in the month of August and extended it up to 10th of October, 9th of October. So that cannot be a ground for setting aside the clause. And there is no such thing that the central government has defined any particular clauses to be incorporated in the tender notice. So this is the assessment of the agency which was entrusted as a nodal agency for implementation.
Whom did you entrust?
Assam Police Housing Corporation. Assam Police Housing Corporation. So this judgment which I have placed, Lordship, this because of the paucity of time, I am not placing this, but in the
Okay, doesn't matter.
a bunch of.
Please mark the paragraphs.
Paragraph also I have marked, highlighted the points, judgments, citations, the party's name, etc. Lordship. Relevant paragraphs are also indicated. These are well settled principles of tender adjudications. This is my humble service.
Oh. Biblo. Third. The M.K. Chaudhary and the senior counsel for this. Step by step. Mr. Ganguly for? AG for all the respondents.
Yes, Lordship. These are all
The
state
respondents
instrumental.
are represented by Sri D. Sekar, the Standard Advocate General, assisted by Sri S. Bora. Both the writ petition as well as the I has been heard. Full stop. Judgment is reserved. You have ensured that you will not allow me to enjoy the view.
That is what I was telling my learned friend, that why did
And you have discharged your burden.
no, why did you spoil the time of the honorable court during the holiday? We could have waited for a few days. Anyway,
There is some compulsion in this case. Otherwise, I would not have pressed for hearing today, Lordship.
Okay, something is over now.
So, deeply obliged.
Others, what to do? Interim orders
My lord,
required to be extended, we will extend. Other matters will have to be given dates.
my lord, item number 68, my lord, regarding settlement for 11 months. My lord. June is the last, my lord. Last it also left over, my lord.
You can have on 19th.
My
Item number
68.
19.
My lord.
Any case interim order is still today.
For item 55, my lord, that Cancer Institute matter. If some urgency, my lord, if your lordship fix it,
Okay, that we can have it on 18th.
Yeah.
Mr. Day, is he around? Mr. Day, yes,
he is there.
18th. That what boy, what
Yeah,
girl?
yes,
Okay.
Obliged.
You have got the order
Yes, we
sheet,
have the
certified copy,
Yes, yes, we have.
and then we can settle the matter.
My lord, no, that is no problem.
Oh, item number
55.
55, 18th, interim order passed to contract to next day.
Obliged.
Any other matter, interim order till today?
Lordship has fixed the matter, item not 54 today, Lordship for disposal with a small direction that the respondents may consider our complaint, Lordship. Lordship may fix the matter.
No, 4 dates, court master will give. Any matter where interim order is still today.
My lord, my item number is 43 and 45 is similar, my lord. So it can be paid on the first week of February.
He'll give a date.
And the 44 is, my lord, there is a little bit of, there is a part matter for regarding a measurement.
He'll give a date.
Okay.
It will date, personally appear. আৰু এখনো তাতে সেইটোত লাগিব এই দুটা লাগিব সেইটো ফাইলত এইটো পইচা
I doubt.
Black